Thank you for tuning into Bond Court. I want to continue posting Bond Court every night on YouTube, but the viewership and engagement on my channel has fallen off a cliff. I would greatly appreciate your help by hitting the like button and leaving a comment on my videos. Thank you and enjoy the show.
Good morning, Your Honor. This is Ricardo Morales, Spanish interpreter. I have been previously sworn.
Good morning. We have two Spanish interpreter initial appearances. So the first one is Arlette Duran, and it's 2022 CF 9565AO.
A ver, ahora sí le escucho, sí.
Your Honor, the interpreter can confirm there's connection.
Okay. Sir, could you tell me your name?
Mi nombre es Arlette Duran.
My name is Arlette Duran.
Okay, Mr. Duran, you were arrested and charged with attempted sexual battery of a child under 12, and then 3 counts of lewd and lascivious molestation of a child under 12. I have reviewed this. I do find probable cause in this matter. And on count 1, attempted sexual battery on a child under 12, that is a first-degree felony, and I will hold you no bond. Special conditions of the bond are that you have no contact with the named victim and that you have no unsupervised contact with any child under 18. And in counts 2, 3, and 4, lewd and lascivious molestation, victim under 12, I'll set bond in the amount of $25,000 per each count. I will appoint the public defender's office to represent you.
Your Honor, count 1, he actually is entitled to a bond. It's just an F1. It is not a
Muy bien.
PBL. Count 2, 3, and 4 are F1s that are PBL. So state would ask that you set bond on count 1 and hold him no bond on 2, 3, and 4.
It's been a while, so I'm going to go ahead
No
and do
problem.
that. On the lewd molestations, leave you set at no bond. On count 1, set you at $25,000. Everything else remains the same.
You appointed the PD.
I did appoint the public defender's office.
Oh, this is... Perdón.
Mr. Interpreter, could you please advise the client that I
¿Me
have
quito esto?
circled the attorney's phone number for him to speak one-on-one about the facts of the case? We have to have an Arthur hearing in order to set bond on counts 2, 3, and 4, as they are punishable by life.
Poco entiendo, hermano, de verdad que entendí algo, pero bueno. Veo que me hablan aquí de unos 25,000.
I see here that you're talking about some $25,000.
That's for count 1. On counts 2, 3, and 4, there is no bond, meaning there's zero amount of money that can get you out of jail. You need to go before the felony judge.
Bueno, yo estoy aquí a lo que ustedes digan, no sé qué hacen.
Well, I'm here to do whatever you guys say. I don't know what else to do.
Sir, I've appointed the public defender's office, which means you now have an attorney. They will be out to see you, to talk to you about this case. In the meantime, I'm sure they would advise you not to talk to anybody else about the facts of your case. Do you understand?
Correcto.
Correct.
Okay, that's all, sir. Thank you.
Gracias también.
And sir, the next case is 2022 CF 6966AO. Ramon Antonio Rivera Pagan. You can leave the no contact whatsoever with any minors. So. All right. Sir, could you tell me your name?
Ramon Antonio Rivera Pagan.
Okay. Mr. Rivera Pagan, you were arrested and charged with trafficking in cocaine, over 400 grams, as well as possession of cannabis, under 20 grams. No, over 20 grams. I have reviewed this. I do find probable cause on both counts. I will appoint the Public Defender's Office to represent you. And on the trafficking in cocaine case, I will set your bond at $500,000. On the possession of cannabis case, I'll set your bond at $5,000. I'm staying the amounts previously set by the judge who reviewed the affidavit for the warrant. Okay. I've appointed the public defender, so someone will be out to talk to you about your case. Oh, also, I'll stay the same conditions, possess no weapons. Thank you. Is that all the Spanish cases we have? All right, I think that's all the Spanish cases we have. Thank you very much.
Thank you, Your Honor. Have a great day.
You too. Okay. And after this gentleman, I would like to do Miss Bellani's client. Female, Amanda Soares. All right. Good morning, sir. Could you tell me your name?
My name is Abdias Dorsily.
Okay, Mr. Dorsally,
Yes.
you were arrested and charged with engaging in public nudity. I have reviewed this and I do find probable cause, and I will appoint the Public Defender's Office to represent you. Sir, I will set a bond in this case in the amount of $1,000.
For what, Judge?
Excuse me?
For what?
That's in order to get out. That's what the bond amount is, sir?
I cannot pay any bond. I think I need a lawyer, and I'm abused in here. Like the sheriff officer, they catch me for no reason, just because I asked them. So why they put my name is Dorsily Abdias? I said my name is Abdias, not Dorsily. They grab me, they put handcuff on my hand, they beat me, they hit me in the bench. Tell me, what does that mean to you?
Okay.
Can
Sir?
you ask the judge the ID for me, please? No, she has to see it. And then they said made
Your Honor.
NCUS 5. What does that mean?
Your Honor, there's,
This is United
we
States
have
of
comp
America, or
concerns. So I
this
just
is
asked that
made NCUS
you stay the bond.
5. Tell me, what does that mean to you, Judge? That's discrimination. That's sex abuse. They do
Okay,
it why? Because
sir?
I'm not born here?
Sir,
Yes.
I've appointed an attorney to represent you, okay?
Okay.
I'm here today. This is initial appearance. So I'm telling you what you're charged with, and we're determining whether or not you qualify for release or whether or not we set a bond on you. I have set a bond so that we have concluded our business here today, okay? Your attorney will be out to see you soon. Good luck to you.
Anthony.
All right, so, good morning.
Judge, how are you?
I'm good. How are you, Ms. Bellani?
I'm doing well.
Okay, and ma'am, could you tell me your name for the record?
Amanda Cristina Pereira Soares.
Okay, Ms. Soares, you were arrested and charged with attempted first-degree murder with a weapon, aggravated battery with great bodily harm, aggravated battery with great bodily harm, as well as a charge of misdemeanor battery. The probable cause was already found in this case. And I have reviewed this and I agree with the probable cause. And Ms. Bellani, would you like to be heard?
Judge, we're asking for a bond in this case. When we she reached out to me yesterday morning. We found out from the marshals that there was a warrant. Immediately, she went and turned herself in to avoid the marshals having to go locate her, pick her up. She's cooperated with, with the marshals at that point. She's got significant ties to the community. I don't believe she has any criminal history. She's a citizen. Her family and her sister both all live here. Like I said, first thing yesterday morning, she was in contact when our office opened to be able to try to retain a lawyer to try to resolve this. I don't think, we didn't know the charge at the time because Marshall told us a different charge, but she does have a significant contact or in the community, so she's not a flight risk. I don't believe I know it's just a dangerous community with no criminal history, especially with her age, and we're just asking for a reasonable bond in this case, Judge.
State?
Your Honor, in regards to the 22 CF 10373, count 1 is a first degree felony that is punishable by life. State's asking that it be stayed at no bond, pending an Arthur hearing, and to set reasonable bonds on 2 and 3, as they're both F2s and she is entitled to a bond on them. Same with the other case, the misdemeanor battery case. I believe it came in with a $1,000 bond. State has no objection to that. State would contend that she is a danger to the community. It appears her behavior is escalating. The misdemeanor battery occurred back in May 28th of 2022. And that one, it is alleged that she pushed another female down, punched her, they fell to the ground. She hit that female in the face, legs, and abdomen, and then later on threatened her by saying, next time it's going to be worse than what I did. Fast forward 4 months, and she's here for the case that occurred on the 5th, which came in as a first-degree murder, or attempted first-degree murder with a weapon, showing that her behavior is potentially escalating and that she is a danger to herself and potentially other members of the community. And in regards to counsel's argument that she has significant community ties, I believe she told PTR that she lives in New Jersey and she's in the process of trying to relocate here. But she's been going back and forth for about a year trying to relocate here. She lives in Jersey. Her mom lives here. So state would argue that she does not have significant community ties. In addition to her potential danger to the community, state would ask, since she's not entitled to a bond on one, that should be held no bond.
Judge, if I may, she actually, we did have this conversation yesterday. Her husband that she has left is in New Jersey, so she's getting her stuff, but she is moving here. Her mom owns a business here locally, and that's why she's actually here now. She's just going back to get her stuff because she's divorcing her husband.
Okay. Ms. Bellani, I think you're going to have to take this up with Judge Barber, so I am going to stay the no bond status on the attempted first-degree murder. There was probable cause found, and actually I agree with the probable cause. I will set bond of $5,000 on the aggravated battery with great bodily harm on each of those counts, and set a bond of $1,000 on the battery charge 2022 MM3633 AO. Special conditions are that she's to have no contact with any of the named victims in this case and possess no weapons. But you can certainly take this up with Judge Barber. Okay?
Judge.
All right. What's the other condition? Leave that as well. Stay in the previous bond. Ms. Bellani left quickly. So I guess maybe she went out that door. All right. Okay. Good morning, sir. Could you tell me your name?
Shelton Nelson Donald Jr.
Okay, Mr. Shelton, you were arrested and charged with disorderly conduct. I do find that there is probable cause in this case. Is there an offer in this case?
Yes, Your Honor, state did convey an offer to Mr. Shelton of an adjudication of guilt, credit time served.
Okay. Mr. Shelton, have you read this plea form, and do you understand the rights you're waiving by entering into a plea?
Yes, ma'am.
Are you entering the plea
Yes,
freely
ma'am.
and voluntarily?
Yes, ma'am.
Are you currently under the influence of any drugs, medication, or alcohol?
No, ma'am.
And do you understand if you're not a United States citizen, entry of a plea to a crime could subject you to deportation?
Yes, ma'am.
And to the charge of disorderly conduct, how do you wish to plead?
No contest.
I'll accept your plea, find you're entering it freely and voluntarily. I will adjudicate you guilty, give you credit for the 2 days that you've served in the Orange County Jail. I will order court costs and the filing fee and reduce them to a civil judgment. You have 30 days to appeal the judgment and sentence of this court. If you cannot afford an attorney for that purpose, one will be provided by the court. I release you as to this charge, sir, okay?
Yes, ma'am.
Good luck to you, sir. Please stay out of trouble.
Okay, have a great day.
You too. All right. Good morning, sir. Could you tell me your name?
Ramon Melendez.
Okay, Mr. Melendez, you were arrested and charged with grand theft third degree, burglary of an unoccupied structure, grand theft third degree, as well as criminal mischief. These are two.
I believe he's only here today on one count of grand theft third degree.
It's an add-on, right?
Is he here on one or both?
He's only on the 10393.
Okay. Are we sure?
Yes, yeah.
Let's see, Mr. Melendez.
Looks like they added on a charge.
10393 is the one in my list.
Mm-hmm.
Has he already gone to IAs on the other case?
Yes, yeah.
Yes, Your Honor.
Okay. All right, then we're only here on 2022 CF 10393 on a charge of grand theft third degree between $750 and $5,000. I do find probable cause, and I will appoint the public defender in that case. And I will set bond in the amount of $2,500 for that charge. Special condition that you have no contact with the named victim in the case. All right. Anyway, anything else, State?
No, Your Honor.
All right, that's all. Thank you. All right. What these arraignments? Okay.
Do it.
All right. Sir, could you tell me your name? Okay, Mr. Joseph, you're here for an arraignment on a charge of operating a motor vehicle without a valid driver's license, a second-degree misdemeanor. This case is in Division 61.
Your Honor, state did convey an offer to Mr. Joseph of an adjudication of guilt, credit time served.
And court costs?
Yes, Your Honor.
Oh, okay. I don't know. Your Honor, we're going to enter a plea of no contest.
All right. Sir, have you seen?
Not no contest. I'm sorry, not guilty.
All right. Then, sir, as far as a pretrial in Division 61, I will appoint the public defender to represent him.
Because he thought it was tied to his grand theft. I didn't see that. I just want to make sure. Set for
I don't see him in here on that case.
Mm-mm. This was 7/27.
He does have an open grand theft motor vehicle, an open carjacking battery, open grand theft motor vehicle Dwillis. But I don't see that they're related.
Mhm. Yeah, it is the same. It is the same. Thank you. We're gonna leave it that way. Can I just get the court date again, Madam Clerk? I'm sorry, I missed it.
October 14th. What is it? 9?
Your Honor, we have Ruefley Matthew as medical.
Okay. Do we have a financial affidavit for him?
Roughly,
Oh, the
arraignment.
arraignment. No, Your Honor, but we will, if you appoint, we will waive and enter a plea of not guilty.
Okay, I will appoint the public defender to represent Mr. Rufel, and they're entering a plea of not guilty on his behalf. Okay. Next, we have Nicholas
Federal
Valentine.
check, Your Honor, is medical also.
The PD was previously appointed on this case.
We will enter denial and waive, Your Honor.
Okay, and he needs a VOP date in Division 83. All right, Troy Luoma. Okay, and he is represented by the Public Defender's Office.
And enter a plea of not guilty.
Okay, sir, your felony was transferred down to a misdemeanor. You're charged with trespass on a structure of a conveyance, criminal mischief, and resisting without violence. They've entered a plea of not guilty for you, and a court date in Division 85. Okay.
That's your next court date.
All right, good morning, sir. Could you tell me your name? Mr. Burgos, you were arrested and charged with possession of drug paraphernalia and possession of cannabis under 20 grams. Both are misdemeanors. Let's see, I have reviewed this. I do find probable cause. Are you seeking the public defender, sir? Yes. I will appoint the public defender to represent you. And I will set bond at $500 on each count for a total of $1,000. Okay, that is all. All right, good morning, ma'am. Could you tell me your name? Okay, Ms. Davis, you were arrested and charged with trespassing in a conveyance, a car. I have reviewed this. I do find probable cause in this matter. I will appoint the public defender to represent you. And I will go ahead and set bond in this matter of $500.
And Your Honor, state would ask for no contact with the victim and no return to the vehicle.
Okay, and I'm ordering no contact with the victim and no return to the vehicle, ma'am. All right, sir, could you tell me your name?
James Gillette.
Hey, Mr. Gillette, you were arrested and charged with trespass on property after warning. This is out at Disney.
Yes.
Okay, I have reviewed this. I do find probable cause in this matter. I will appoint the public defender to represent you.
Your Honor, state did give me an offer to Mr. Gillette of an adjudication of guilt, credit time served, and no return to any of the Walt Disney World properties, including Disney Springs.
Would you like to accept and enter a plea of no contest?
Sir, have you seen a plea form before, and do you understand the rights you're waiving by entering into a plea?
Right.
Are you entering the plea freely and voluntarily?
I'm sorry, say again?
Are you entering this plea freely and voluntarily? Is anyone forcing you to do this
Oh,
against
no,
your
no,
will?
No, no.
Okay, so you're doing this of your own free will?
Yes, I am.
That's all I'm trying to find out,
Yeah,
sir.
Thank you.
Okay, are you currently under the influence of any drugs, medication, or alcohol?
No, I've never done it in my entire life.
Okay, were you on any criminal probation at the time of this
Never
offense?
in my life.
And do you understand if you're not a United States citizen, entry of a plea to a crime could subject you to deportation?
I'm sorry, say that again?
Do you understand if you're not a United States citizen, entry of a plea to a crime could subject you to deportation?
I am a United States person.
Okay, I just say this to everybody because I don't know who is or is not, and I need to advise them, all right? Okay, then to the charge of trespass on property after warning, how do you wish to plead?
No contest.
All right, I'll accept the plea, find you're entering it freely and voluntarily. I will adjudicate you guilty, give you credit for the
2 days.
2 days that you've served in the Orange County Jail. I'm going to order that you not return to any Walt Disney properties.
Right, okay.
Okay, they don't want you there.
Right,
It's
I-
just going to be trouble for you.
Thank
It's expensive anyway, right? Okay. And I'm also ordering court costs and reducing them to a civil judgment. You have 30 days to appeal the judgment and sentence of this court. If you cannot afford an attorney for that purpose, one will be provided by the court, okay? I release you as to this charge.
Okay, thank you.
Thank you.
No.
Not with me.
Daniel Harp.
All right. Good morning. Sir, you are charged with trespass on property after warning. I have reviewed this. I do find that there is probable cause in this matter.
Your Honor, state did convey an offer to Mr. Harp of an adjudication of guilt, credit time served, and no return.
And he would like to accept and enter a plea of no contest, Your Honor.
Okay. Sir, have you previously seen a plea form, and do you understand the rights you're waiving by entering into a plea? Are you entering the plea freely and voluntarily? Are you currently under the influence of any drugs, medication, or alcohol? Were you on a criminal probation at the time of this offense? And do you understand if you're not a United States citizen, entry of a plea to a crime could subject you to deportation? Then to the charge of trespass on property after warning, how do you wish to plea? I'll accept the plea, find you're entering the plea freely and voluntarily. I will adjudicate you guilty, give you credit for the
2 days.
2 days that you've served here in the Orange County Jail. Order that you not return to
It's the Ivy Lane Apartments.
the Ivy Lane Apartments. They don't want you there. If they see you there, you're going to get arrested again. Do you understand that? All right. I'm also ordering court costs, reducing them to a civil judgment. You have 30 days to appeal the judgment and sentence of this court. If you cannot afford an attorney for that purpose, one will be provided by the court. I'm releasing you as to this charge, sir. Good luck to you. Please stay out of trouble. All right? All right. Good morning, ma'am. Could you tell me your name?
Tara Price.
Okay, Ms. Price, you were arrested and charged with trespass on property after warning. I have reviewed this. I do find probable cause. And ma'am, you're currently out on some sort of release. I don't know if it's a bond.
Your Honor, I would ask that you take no action on the out on bonds. She's in comp proceedings.
Okay. All right. Ma'am, as far as the trespass on property after warning, I'm going to go ahead and I'm going to appoint the public defender to represent you. I will set your bond in the amount of $1,000. And I will take no action on the cases that you're currently out on, these misdemeanors. You have 3 separate misdemeanors, okay? Yes, ma'am.
Just got out of jail a couple of days ago, yesterday maybe. And I'm just a veteran. I by the VA. I'm in the HUD dash program. I don't have anywhere to go. I am in the housing program with the VA. And that apartment complex is near there, and I was taking a shower at the pool. I was not harming anybody. I do apologize. But I really don't have any money, Judge, and I don't have anywhere to go until the VA helps me find a house, until I get an apartment.
Well, ma'am, I guess the problem that I have is that you're currently out on a release. I could revoke all of those releases. I'm not going to do that. But you're basically asking me to release you on your recognizance, whereas, you know, we have you going somewhere where they're saying that they've told you don't go. So. Ma'am, I'm going to reduce the bond. I'm going to set the bond at $250. Okay, I have appointed the public defender to represent you. They will be out to see you soon. Okay, I think they're indicating that they're having doctors talk to you. So I suggest you cooperate with them. All right, and I do wish you luck. Okay. Okay. Good afternoon, sir. Could you tell me your name?
Pedro Rodriguez.
Okay, Mr. Rodriguez, you were arrested and charged with trespass on property other than a structure or conveyance, apparently a 7-Eleven. I have reviewed this. I do find that there is probable cause. I will appoint the public defender to represent you. And on that case, I will go ahead.
There's an offer to resolve the case of an adjudication credit time served and no return to 1201 North Cimarron Boulevard in Orlando, Florida. And Mr. Rodriguez would like to accept and enter a plea of no contest.
Okay, sir, have you read through the plea form and do you understand the rights you're waiving by entering into a plea?
Yes, ma'am.
Are you entering the plea freely and voluntarily?
Yes, ma'am.
Are you currently under the influence of any drugs, medication, or alcohol? Were you on a criminal probation at the time of this offense? And do you understand if you're not a United States citizen, entry of a plea to a crime could subject you to deportation? Then to the charge of trespass on property other than a structure or conveyance, how do you wish to plea?
No contest.
I'll accept your plea, find you're entering it freely and voluntarily. I will adjudicate you guilty, sentence you to time served, release you as to this charge, order that you not return to 1201 North Cimarron Boulevard, Orlando. And I will order court costs and reduce them to a civil judgment. Sir, you're currently out on bond on 3 different cases. I could revoke that bond. You understand that?
Yes, ma'am.
I'm not going to do that. I'm going to leave your bonds alone, even though you have now pled to a criminal charge while you're out on bond. Do you understand?
Yes, ma'am.
Okay. So you need to stay out of trouble because the next time you're going to end up sitting with no bond. Do you understand?
Yes, ma'am.
All right. You have 30 days to appeal the judgment and sentence of this court. If you cannot afford an attorney for that purpose, one will be appointed by the court.
Your Honor, Joseph Watson's behavior.
Okay.
And Your Honor, could we just reset this for tomorrow?
Yes, we'll reset them to tomorrow. All right. Good afternoon, ma'am. Could you tell me your name? Okay, Ms. Dockery, you are here on a failure to appear on 2022 MM 2810AO. The failure to appear was from May, and the judge in that case set you at no bond, and I will stay the no bond status.
You said us 2,000?
2,000.
They set the bond at 2,000.
They did? I thought well, if you all agree that it's 2,000, then I'll leave it at 2,000.
Okay.
Okay. I thought it was no bond, but. You are correct. It is 2,000. And was the public defender previously appointed?
No. No, there's no attorney, Your Honor.
Okay, I will appoint the public defender to represent you, ma'am.
No, I don't have it.
All right, good afternoon, ma'am. Could you tell me your name? Okay, Miss Washington, you are here on a failure to appear for missing court on August 22nd. The judge in that case has set a bond of $1,000 on that warrant, so I will stay that. And then you also have a new charge of petty theft from Walmart. I've reviewed this. I do find probable cause. I will appoint the public defender to represent you, and I will set a bond of $1,000 with the special condition that you not return to the Walmart where this occurred. Anything else, State?
No, Your Honor.
Okay, that's all. All right, good afternoon, ma'am. Could you tell me your name?
Trinity Cockrell.
Okay, Ms. Cockrell, you are here on a charge of disorderly conduct. I've reviewed this, and I do find that there is probable cause for the disorderly conduct charge.
Your Honor, state conveyed an offer of a withhold credit time served.
Your Honor, I'm gonna ask for a pretrial release given she has no criminal history that I see.
State has no objection.
Okay. Ma'am, I am going to release you on pretrial release, given your lack of criminal history. Conditions of your pretrial release are that you possess no weapons and you have no contact with any named victim in the case. Do you understand?
Yes, ma'am.
Okay, please stay out of trouble, ma'am.
Yes, ma'am. Thank you.
Thank you. Who bonded?
I know, they have put a fat on her. They should have called her back. I heard them tell them to call her back on the court list.
Who do we have right here?
Ishmael Cisse.
Okay. Mr. Cisse. This one, okay. All right, sir, you were arrested and charged with disorderly conduct and state misdemeanors, meaning resisting an officer without violence. I have reviewed this. I do find probable cause. I will appoint the public defender. And sir, you're also currently out on bond for a grand theft third degree in Osceola, and that's for 2022 CF 1783. Okay.
In regards to his new city case, Your Honor, state did convey an offer of a withhold credit time served.
On both counts?
Yes, Your Honor. He has no other convictions.
Yes, Your Honor.
Would he like to accept that offer?
Yes, Your Honor.
All right.
And enter a plea of no contest. Thank you.
All right. Sir, did you read through this plea form and do you understand the rights you're waiving by entering into a plea?
Yes, ma'am.
Are you entering the plea freely and voluntarily?
Yes, ma'am.
Are you currently under the influence of any drugs, medication, or alcohol?
No, ma'am.
Were you on a criminal probation at the time of this offense?
No, ma'am.
And do you understand if you're not a United States citizen, entry of a plea to a crime could subject you to deportation?
Yes, ma'am.
And to the charge of disorderly conduct, how do you wish to plea?
No contest.
And to the charge of state misdemeanors, in this case, it's resisting without violence, how do you wish to plea?
No contest.
I'll accept your plea, find you're entering the plea freely and voluntarily. I will withhold adjudication, give you credit for the 2 days that you've served in the Orange County Jail.
1 day, Your Honor.
1 day you've served in the Orange County Jail, order court costs and the filing fee, and I will reduce that to a civil judgment, sir. As to your grand theft third degree that you're out on bond for, I'm going to take no action on that bond, okay? Don't mess up again, because next time they're going to end up revoking that bond. Do you understand?
Yes, ma'am.
Okay, I'm releasing you as to this charge, sir. All right. Good afternoon, sir. Could you tell me your name?
Andrew Dion Hooks, ma'am.
Hey, Mr. Hooks, you are here on a failure to appear warrant issued by Judge Walker, and he set your bond at $2,000 in this matter, and I will stay that bond. Does he already have the public defender?
Yes, Your Honor, there was an offer to resolve. Hey, son.
Okay.
Of an adjudication credit time served, there's a cost investigation in the amount of $73.36 to the Orlando Police Department, and Mr. Hooks would like to accept and enter a plea of no contest. And we are appointed, so I'm asking for the,
Okay.
Thank you.
Is this a Dwellis or a no valid?
No valid.
Thank you. All right. Sir, have you read through the plea form and do you understand the rights you're waiving by entering into a plea?
Yes, ma'am.
Are you entering the plea freely and voluntarily?
Yes, ma'am.
Are you currently under the influence of any drugs, medication, or alcohol?
No, ma'am.
Were you on a criminal probation at the time of this offense?
No, ma'am.
And do you understand if you're not a United States citizen, entry of a plea to a crime could subject you to deportation? Then to the charge of no valid driver's license, how do you wish to plea?
No contest.
I'll accept the plea, find you're entering the plea freely and voluntarily. I will adjudicate you guilty, give you credit for the
4 days.
4 days that you've served in the Orange County Jail, release you as to this charge. I'm ordering court costs and costs of investigation. Costs of investigation are $73.36 payable to Orlando Police Department. Sir, do you have a job?
Not at the moment.
Not at the moment. Okay, I'm going to reduce those to a civil judgment. You have 30 days to appeal the judgment and sentence of this court. If you cannot afford an attorney for that purpose, one will be provided by the court. Good luck to you, sir. Please do not drive without a valid driver's license. Do you understand?
Yes, ma'am.
Okay, thank you. All right, good afternoon, sir. Could you tell me your name?
Michael Adam Male.
Hey, Mr. Adams, you were arrested and charged with possession of cocaine, a third-degree felony. I have reviewed this. I do find probable cause in this matter, and I will appoint the public defender to represent you. And, sir, you do qualify for pretrial release in this matter, so I am going to release you on pretrial release. The special condition that you possess no unprescribed medications. Do you understand? All right. That is all. All right. Good afternoon, ma'am. Could you tell me your name?
Christy Battleson.
Okay, Miss Battleson, You were arrested and charged with possession of cannabis over 25 pounds, possession of cannabis over 20 grams, sale and delivery of cannabis without consideration, drug equipment, possession of paraphernalia. I have reviewed this. I do find probable cause, and I will stay the previous bond.
Your Honor, I would just ask that, I believe it's count 3. I would ask if you would consider reducing that to 5,000, being that count 1 is already set at 100,000.
All right, on count 1, it's set at 100,000. Count 2, 1,000. Count 3, I'll reduce that to 5,000. Count 4, 1,000. I will appoint the public defender to represent you. That is all. All right. Good afternoon, sir. Could you tell me your name?
Maurice Bale.
Okay, Mr. Bell, you were arrested and charged with possession of MDMA or ecstasy. I have reviewed this. I do find that there is probable cause. I will appoint the public defender's office to represent you. And I will stay the, I believe it's $1,000. Yes, I will stay the bond at $1,000. Okay, that is all. All right. Good afternoon, sir. Could you tell me your name?
Deshae Brown.
Okay, Mr. Brown, you were arrested and charged with burglary with a battery or with an assault or battery therein, which is a first-degree felony punishable by life. And you're also charged with criminal mischief between $200 and $1,000. I have reviewed this. I do find probable cause in both cases. On the punishable by life count 1, I will stay the no bond status. And on the criminal mischief, I will set bond in the amount of $500. Special condition of any bond is that you have no contact with the named victim, that you not return to the scene, and that you possess no weapons. That is all. And I will appoint the public defender to represent you.
Hey, man, robbery, some snatching that TV.
All right, sir, could you tell me your name?
Booker Davis.
Okay, Mr. Davis, you were arrested and charged with burglary of an occupied dwelling with an assault or battery therein, which is a first-degree felony punishable by life. I have reviewed this. I do find probable cause. I will appoint the public defender to represent you.
Your Honor, I believe he was here on that charge yesterday. I believe today he's only here for the attempted sex bat.
Ah,
They added on a charge, Your Honor.
I see. Okay,
He is entitled.
nice. All right, and then on the attempted sexual battery, that's on the next page. Okay. I've reviewed that. I do find probable cause in that. I'll appoint the public defender's office on that charge. Is that an F1?
No, Your Honor, he is entitled to a bond on it. I believe he already is sitting no bond due to the Berg bat. So just ask that you set a reasonable bond.
Okay, I'll set bond in the amount of $25,000. Special condition that you have no contact with the named victim, that you not return to the scene. And I've appointed the public defender to represent you, sir. Okay. Thank you.
Hey, Judge. How can I live there? I didn't burglarize anything.
Stop talking about the facts.
I have to.
Sir, it's not going to make it, sir, it's not going to make a difference, so you need to just talk to your attorney. Anything you say here can and will be held against you in a court of law, so it's not to your benefit.
Your Honor, we have Esther's next because his behavior.
His behavior?
Yeah.
Well, that's a shame because he qualified for PTR, but.
I know.
And given that he does qualify, I was gonna ask for pretrial release. I don't,
No, he can show up and ask for it, but just because he qualifies, I'm not quite sure why he qualifies. I wasn't really inclined to do that for him anyway.
okay.
I have reviewed this. I will find probable cause. I will appoint the public defender's office. And we can either reset it for tomorrow.
Yes.
Okay, let's reset Esther's for tomorrow. If he doesn't show up tomorrow, we'll figure it out from there. Could you tell me your name?
Jessica Ford.
Okay. You were arrested and charged with possession of MDMA and ecstasy, as well as possession of drug paraphernalia. And I have reviewed this. I do find probable cause. I will appoint the public defender to represent you. And on the possession of MDMA, I'm setting bond in the amount of $1,000. And possession of paraphernalia in the amount of $100. You're currently out on bond on another drug charge. And actually, you're out on ROR. I am going to revoke the ROR and set you at $1,000 on that charge. And that's on 2022 CF 2571AO. I've appointed the public defender on all charges. Okay. Is Mr. Gandy?
Yes, ma'am.
Sir, you were arrested and charged with robbery with a firearm, which is a first-degree felony punishable by life. I have reviewed this. I do find probable cause. I will appoint the public defender's office, and I will leave you set at no bonds. Special conditions of when you do bond out are that you have no contact with the named victim, as well as possess no weapons. That is all. All right, sir, could you tell me your name?
Jonathan Gutierrez, Your Honor.
Okay, Mr. Gutierrez, you were arrested and charged with possession of methamphetamine, a third-degree felony, as well as possession of drug paraphernalia, a first-degree misdemeanor. I've reviewed this. I do find probable cause. I will appoint the public defender's office. Is he on probation right now?
He is, Your Honor.
He is on probation?
He is. Okay, on the possession of methamphetamine, I will set bond at $1,000. Possession of drug paraphernalia, set bond at $100. Okay. Is there an on-view VOP? There isn't, but he has the VFOSC hold, so he won't be getting out.
Okay, all right. That is all, thank you. All right, good afternoon. Could you tell me your name?
Sir Ellis Jacobs, Your Honor.
You're Mr. Jacobs?
Yes, ma'am.
Okay. Sir, you were arrested and charged with possession of ammunition by a convicted felon. as well as possession of cannabis with intent to sell and deliver, and possession of cocaine. All of these are felonies. I have reviewed these. I do find probable cause. I will appoint the public defender on these matters. And on the possession of ammunition by a convicted felon, I'll set bond in the amount of $2,500. Possession of cannabis with intent to sell or deliver, set bond at $1,000. Possession of cocaine, set bond at $1,000. Sir, you're also currently out on bond. For trespass in a structure, your bond on that matter is $2,000. I'm going to revoke that bond and double it and reset that for $4,000. That's on 2021 MM 6474BO. And you're out on bond for possession of Utilone, and that's a $1,000 bond. I will revoke that bond and double it and set it at $2,000. That's on 2021 CF 4581AO. Okay. I've appointed the public defender to represent you, sir. Okay. That is all.
Your Honor,
Yes.
Laguerre Angelo is mental health.
And I will waive, Your Honor.
Okay.
And I would just ask that you set bond or mental health pretrial release if he qualifies. Not sure if he will, but due to the mental health issues.
Okay. On Laguerre, I find probable cause. I'll appoint the public defender's office. They're waiving his appearance. On the grand theft of a motor vehicle, I'm setting bond at $1,500. On the trespass, I'll set bond at $500. Special condition that he have no contact with the named victim in the case. And that's all. Okay. Good afternoon, ma'am. Could you tell me your name?
Lancaster, Rachel.
Okay, Ms. Lancaster. You were arrested and charged with battery on a law enforcement officer, trespass on property after warning, resisting an officer without violence, and criminal mischief. I have read through this. I do find probable cause for all of the charges. I will appoint the public defender's office to represent you. On the battery on a law enforcement officer, I'm setting bond at $1,000. On trespass on property after warning, $500. On resisting without violence, $500. Criminal mischief, $500. Special conditions are that you have no contact with the named victim in this case. Any other conditions state?
No, Your Honor.
Okay, that's all. Thank you. All right. Sir, you were arrested and charged with sale or delivery of fentanyl, a second-degree felony, and unlawful use of a two-way communication device. I've reviewed this. I find probable cause on both counts. On the sale and delivery of fentanyl, I'm setting bond at $5,000. And on the unlawful use of a two-way communication device, setting bond at $1,000. I will appoint the public defender to represent you. Sir, apparently you have an out-of-county warrant. I don't know what it's about either, sir, but that's what you have. So you have an attorney appointed, okay?
Your Honor, Murtazen is bonded.
Christelle Myrtle?
Yeah.
Okay. They're bonded, all right. James Raleigh Owens?
No, Your Honor. Yeah.
Oh, so she is here.
She is here.
Yes.
Okay. All right. All right. All right, good afternoon, ma'am. Could you tell me your name? Ms. Myrtle, you are here on a charge of possession of cocaine, a third-degree felony. I've reviewed this. I do find probable cause. I will appoint the public defender to represent you, and I'm setting bond in the amount of $1,000. And that's all. You, Mr. Owens? All right. Sir, you were arrested and charged with robbery with a deadly weapon, aggravated battery with a motor vehicle on a person over 65, as well as petty theft. I have reviewed this. I do find probable cause on these matters. Let's see. Are you currently on probation, it looks like? Is that correct? All right. Sir, let me see here.
Your Honor, count 1 is an F1 PBL, so state would be asking for no bond.
Okay, well, that's what I thought. Okay, so on count 1, it's a first-degree felony. You're not entitled to a bond on that, and I'm going to leave you set at no bond. Aggravated battery with a motor vehicle on a person over 65. I'll set a bond of $20,000 on that, and on the petty theft, I'll set a bond of $1,000. Special conditions, you're to have no contact with any named victim in the case and possess no weapons, sir. Okay, and I will appoint the public defender to represent you. Yes, and no return to scene.
Israel Pagan.
Not in here. Not in this robe. All right. Sir, could you tell me your name?
Israel Pagan.
Okay, Mr. Pagan.
Your Honor, I will waive the reading.
All right. Sir, you were arrested, and I find probable cause for the charge here. I will appoint the public defender to represent you. This is a punishable by life offense.
Your Honor, I don't believe it is. I believe he is entitled to a bond.
It's an attempt.
Attempted 12
Yes, Your Honor.
or over.
I believe the attempt knocks it down.
Okay. Is it an F1 or F2?
I believe it's an F2, Your Honor.
Okay. Sir, I'm going to set bond in the amount of $100,000. Special conditions are that you're to have no contact with the named victim in this case. Any other conditions state?
Your Honor, I would object to a $100,000 bond. In this case, given he has no criminal history, that's tantamount to no bond at all. He has community ties, never been in trouble. My client's not going to be able to afford a $100,000 bond. So I would ask that you consider reducing the bond at least to $25,000, like you've done before. Given that he has nothing on his criminal record, Your Honor.
State?
Your Honor, state will leave it within your discretion, given the allegations within the affidavit and the charge. It does appear that he is employed, so he will potentially have some funds or collateral.
Okay. I've appointed the public defender to represent you. I will reduce the bond to $50,000. Same conditions. You are to have no contact with the named victim. Judge. What did I do? Kicked myself out. All right, good afternoon, sir. Could you tell me your name? Okay, Mr. Perron, you were arrested and charged with aggravated stalking after an injunction, as well as public orders crime, installing a tracking device. I reviewed this. I do find probable cause. Let's see.
Your Honor, when setting bond, state we just ask that you take into account Mr. Perron currently has an open non-arrest 22 violation of domestic injunction has not yet been filed on. Victim being the same victim. He had a previous stalking, dating, violence, petty theft, criminal mischief from 2021. Victim being the same victim, she declined to prosecute that stalking. He had a 2021 Agbat DV false false imprisonment in DV. Victim being the same victim, she did not respond. He had a 2017 violation of domestic injunction. In that one, it was a different victim. A 2016 false imprisonment, BAT DV. That one also being a different victim than the other two. And then a 2014 juvenile violation of domestic injunction, also being a different victim. We just ask that you take all that into account when setting his bond, as it appears to be a continuous pattern with his partners. We just ask that you take that into account, as state's not asking for no bond on one, as I believe there's things this court can do to ensure his compliance with the injunction.
Your Honor, the one thing I'm going to point out in all of those is that no formal charges were ever filed against him. He was arrested for all those things, yet there is no convictions on his record. So I just ask that you consider that when setting the bond.
Well, probable cause was found by Judge Pender Rodriguez in this case for aggravated stalking after an injunction. I reviewed the same fact pattern. It does appear to definitely have probable cause, that there is an injunction in place, and that there is a breach of this injunction going on. I have a lot of concerns about you, sir. You don't seem to follow the rules. I'm not asking for you to comment because I know your attorney is going to jump up and tell you not to comment right now, okay? Judge Pender Rodriguez left you set at no bond. I am going to go ahead and set a bond, okay? But I have an obligation to protect the community. And if there's already an injunction in place and you're ignoring that, I'm going to give you one more chance, sir. I'm going to set bond on count 1 in the amount of $50,000, on count 2 in the amount of $1,000. Special condition, you have no contact with the alleged victim and that you do not possess any firearms or any weapons, okay? Any violation of this, there's already an injunction telling you not to do this. By all accounts, it looks like you are doing this. I don't know. Any violation of this, you're going to end up sitting no bond. Do you understand? Okay. You can take it up with the judge in your felony division. Thank you. All right. Good afternoon, sir. Could you tell me your name?
Oh, man. Pierre Christopher.
And your last name?
Yeah.
Okay, Mr. Pierre, you were arrested and charged with battery on a law enforcement officer, resisting an officer with violence, as well as possession of cocaine. I have reviewed this. I do find that there is probable cause. I will appoint the public defender to represent you on this case. And I will set bond on battery on a law enforcement officer, $1,000, resisting with violence, $500, possession of cocaine, $500. And that is all, sir. I've appointed the public defender to represent you.
Your Honor, we have Paul Troncoso as medical.
Okay, Jose Enrique Poltroncoso.
And I will waive, Your Honor, if you appoint.
All right, I've reviewed this. I do find probable cause. I'll appoint the public defender. I am going to set bond. Possession of cocaine with intent to sell or deliver, the amount of $7,500. Possession of cocaine, $1,000. Possession of fentanyl, $1,000. Possession of paraphernalia, $500. He's currently out on bond on an aggravated
battery on a pregnant person in 2022 CF 9831AO. I am going to revoke his previous bond and set a new bond in the amount of $5,000 on that case. Special condition, he is to have no contact with the named victim in that case. And possess no weapons. Sir, could you tell me your name?
Mark Anthony Rodriguez.
Okay, Mr. Rodriguez, you are here on a charge of driving while license suspended or revoked as a habitual traffic offender. And it appears on its face that you caused an accident. And you're also on probation currently. So I have reviewed this. I do find probable cause. I will appoint the public defender to represent you on the driving while license suspended or revoked as a habitual offender. I'm setting bond in the amount of $2,500. Is there a VOP pending?
No, Your Honor.
Okay, well, there will be one shortly. But I've appointed the public defender to represent you, sir. All right. Good afternoon, ma'am. Could you tell me your name?
Laura Lynn Stats.
Okay, Ms. Stats. You are here on a failure to appear in front of Judge Strobridge. You're already represented by the Public Defender's Office. When you failed to appear, Judge Strobridge issued a warrant and set you at no bond. I will stay the no bond status, and you can take that up with Judge Strobridge. That is all. Sure. Circle back. All right. Good afternoon, sir. Could you tell me your name?
Anthony Tash.
Okay, Mr. Tash, you were arrested and charged with trafficking in fentanyl, 20 grams or more. This is a first-degree felony punishable with a 25-year minimum mandatory. You're also charged with possession of methamphetamine with intent to sell. I reviewed this. I do find probable cause.
Your Honor, state did file an information. May I approach?
Yes.
Different charges. Count 1, we filed a trafficking in 28 or more.
Okay. All right. So, sir, the state has filed charges. The first count has a 25-year minimum mandatory. The second charge has a 3-year minimum mandatory. And on count 1, I will set bond in the amount of $500,000. On count 2, I will set bond in the amount of $50,000. I will appoint the public defender to represent you, sir. And that is all.
Your Honor, Tavares bonded.
Okay.
Thompson, approach.
All right. All right. Good afternoon, ma'am. Could you tell me your name?
My name is Shizelle Thompson.
Okay, Ms. Thompson. You are here on a charge of trespass on a designated construction site, which is a third-degree felony. I've reviewed this. I do find probable cause in this matter. And I will appoint the public defender to represent you. And I will set bond in the amount of $1,000 with the special condition that you not return to the place where you were arrested. Okay. Yes. A
Queen Tavares bonded.
Your Honor, we have Mr. Williams as juvenile court. He went to another court hearing.
What?
Will he be coming back here? He's
No.
45 years old.
He he went to juvenile court.
He's probably there as a witness, maybe?
Yeah, or for one of his children.
Be a Shelton.
Yeah.
hearing.
Should we reset him to tomorrow? Let's reset him to tomorrow.
Okay.
Bobby Jermaine Williams. Okay.
Lawyer Wilson.
All right. Good afternoon, ma'am. Could you tell me your name?
Lawyer Wilson.
Okay, Ms. Wilson, you were arrested and charged with multiple things, including 2 counts of battery, 1 count of resisting a merchant, 1 count of criminal mischief, 1 count of resisting an officer with violence, and then a separate case of petty theft. I have reviewed this.
When that came?
Excuse me?
When the separate case came?
Take a look. Is she here on that one?
Yes. She's here on both, Your Honor.
On both cases? Okay. Okay. The petty theft, there was an affidavit to issue a warrant.
It was for Dollar General, Family Dollar, excuse me, on August 6th.
August 16th, Family Dollar on West Colonial Drive, shoplifting. Okay, so probable cause was already determined in that case. And
Jail August 16th. I came to jail.
excuse me?
I came to jail August 16th in the kill time. Yeah. I came to jail August 16th. I was here.
Well, there's no way for me to check that right now. I'm going to appoint the public defender to represent you on that, on all of your cases, okay, all of your charges. The bond on the petty theft on 2022 MM 6021AO was set at $500 by Judge Cameron. I'm going to go ahead and stay that bond with a condition of no return.
These bonds so high. I don't have that kind of money. I just bonded out not even 2 weeks ago.
Do you all show that she bonded out on that charge?
No, but she was in jail on August the 16th, but it was on a whole different case.
Okay.
Harassment. Yeah, OPD is harassing people. Just like that lady said, I put those things on.
All right, ma'am, I'm finding probable cause. I'm appointing the public defender to represent you. I'm getting kicked out of here by my computer. Okay, and then in your felony case, on the charge of resisting with violence, I'm setting bond at $1,000. On the criminal mischief, I'm setting it at 250, resisting a merchant 250, and the 2 battery counts at 100 and 100. Special condition that you not return to the scene, and that you have no contact with any named victims and possess no weapons. And I've appointed the public defender to represent you, ma'am. Okay. Is this Woodson?
Yes, ma'am. How you doing this morning?
I'm okay. How are you? How are you doing?
I'm trying to do better, but you know how it is.
I do know how it is, but maybe not. Okay, sir, you were arrested and charged with possession of cocaine. I've reviewed this. I do find probable cause. I will appoint.
If you don't mind, like it wasn't no like.
Stop.
Sir, today's not the day to make your argument. I'm not going to be able to do anything about it anyway. I am appointing the public defender to represent you. I did find probable cause. I will set bond in the amount of $1,000, okay? And then you'll have a court date in front of the judge where this is assigned. Okay?
Off of $1,000, what is my bond? $100 through a bail bondsman company?
It's whatever deal you make with your bail bondsman. It tends to be 10%, but it's a private contract. I can't do anything about that.
Yes,
All
ma'am.
right? Thank you. Are we ready on, is this Mr. Starr?
Thank you.
All right. Sir, could you tell me your name? Okay, Mr. Starr, you are here on an out-of-county warrant. Do you have it? You have an out-of-county warrant, contempt of court for,
Your Honor, I believe he's only here for the cocaine.
he's only here for the new one? Anyway, the out-of-county warrant was for Hillsborough. And then you're also here on a charge of possession of cocaine. I've reviewed this. I do find probable cause, and I will set bond at $1,000 and appoint the public defender to represent you in that matter. And on your out-of-county warrant, I'll stay the $500 bond. So,
Ma'am, may I ask a question? I can bond that right here on both of them, right?
you could. You have bonds on both of them.
Oh, so I ain't got to go way to town for them.
You should be able to post that bond here through any bondsman.
Yes, Your Honor.
Okay?
All right.
All right. Good luck to you, sir. Stay out of trouble. All in favor. Who do we have? Rainey, you had some paperwork for somebody.
We do. Let me speak to her really quick.
Okay.
Have a moment, Your Honor.
Is that Tynese? Rainey?
Yes.
Okay.
Say your name.
Tynese Rainey.
Yes.
And
Okay, ma'am, you were arrested and charged with disorderly conduct for some sort of scrap downtown.
Your Honor, there was an offer to resolve. However, she's currently in pretrial diversion. Plea may kick her out. Just picking up the new charge may kick her out, but I don't know how it's going to affect her pretrial diversion, given she doesn't have any other criminal history. I'd ask that you set a $250 bond and then take no action on the out-on bond, given that she has no other criminal history.
What's she in diversion for?
It looks like carrying a concealed. Do you have a permit?
The carrying concealed firearm, she's in diversion for that?
Yes, she actually had a license. She just didn't have the concealed permit.
Okay. So on the disorderly conduct, I do find probable cause. I will appoint the public defender to represent you, and I will set a bond at $250 on that matter.
Weed and rock. It's a private.
You're currently out on bond for $2,500 on your carrying a concealed firearm. What assurances do I have that you're not going to screw up again?
I'm going to stay out of trouble, ma'am. I have kids.
Okay. I'm going to take no action on that. I don't know what that's going to do to your diversion. Okay, but stay out of downtown at night. Okay? Good luck to you.
Your Honor, we have an attorney here for a case that we heard a little while ago.
Mr. Austin Perron, this is Erin Berry with the Corey Cohen Law Firm.
Okay.
This was the ag stalking, installing a tracking device case, Your Honor. I believe you set the ag stalking after an injunction at 50 grand and the installing a tracking device, you state it at 1,000 with a condition of no contact, no weapons.
If we may address this to the $50,000 bond, we'd ask for a lower amount. He is the primary caregiver to a mother who is completely wheelchair bound, that she needs him in order to be able to make it to critical appointments. And he currently has Crohn's disease and scoliosis, and he's not able to get the necessary medication while in custody. So considering his health and the health of his mother, who he's having to help, who is also caring for a 7-year-old child, while completely wheelchair bound, we would ask for a bond amount that's lower than $50,000.
Your request is denied. My inclination was almost to hold him no bond, if only because he's entitled to a bond. Did I give him a $50,000 bond? I don't think he is really all that interested in paying attention to any judge's orders, and given his history, his background, I don't know really how to protect the community against him. So, all right, so your request is denied. That's all.
Thank you, Your Honor.
Interpreter, I have been previously sworn.
Good morning. We just have one Spanish IA this morning. In the case number, oh, that's a good question. I'll get back to that. So, you could, thank you.
Your Honor, the interpreter can confirm there's connection to the headsets.
Great. Before we get started, the case number is 2022 CF 10422 AO, Wanda Santos Serrano. All right. Good morning, ma'am. Can you tell me your name?
Wanda Janet Santos Serrano.
Wanda Jeanette Santos Serrano.
Okay. And ma'am, you were arrested and charged with battery, domestic violence, as well as abuse of an elderly or disabled person. I have reviewed this. I do find probable cause.
Your Honor, I was going to argue no PC as to abuse of elderly or disabled adult. Based on the facts here, it seems to be a domestic violence dispute between her and her husband. There was no a bruising on his chest. It seems to be an altercation that they had between each other. But I don't see any facts that would indicate that she was abusing the victim in this case.
Your Honor, I believe another charge, as the officer wrote it, would potentially be a battery on a person over 65. Instead of abuse of an elderly person, I think maybe it was a Scribner's error. I do believe there would be a bat on a person over 65 instead of an abuse of a elderly or disabled adult. I don't believe there's any facts to indicate he is disabled. So state would just ask that you find PC for battery on a person over 65, which I'll pull the statute for the clerk.
Okay, I do find probable cause for a charge of battery on a person over 65, which is a third-degree felony, and also for misdemeanor battery. And I will set bond in the amount of $2,500 on the battery on a person over 65, and $500 on the domestic violence battery for a total of $3,000. Special conditions. Well, I will appoint the public defender's office. Special conditions are that you have no contact with the named victim, since there's no one here to say any different. Also, that you possess no weapons and that you not return. Well, actually, you can return once to gather your belongings, accompanied by law enforcement.
And, it's not Madam Clerk. The statute is 784.08, sub 2, sub C.
Okay. Anything else, State?
No, Your Honor.
All right. Thank you, ma'am. And thank you, Mr. Interpreter. We'll talk to you later.
Thank you, Your Honor. Have a great day.
You too. Okay, good morning, sir. Could you tell me your name?
My name is Eric Cruz.
Okay, Mr. Cruz, you were arrested on a charge of disorderly conduct.
And, Your Honor, this was reset from yesterday. The offer to resolve the case was a withhold of adjudication credit time served, and Mr. Cruz would like to accept the state's offer and enter a plea of no contest.
All right. So, sir, did you read through the plea form, and do you understand the rights you're waiving by entering into a plea?
Yes, I do.
Are you entering the plea freely and voluntarily?
Yes, ma'am.
Are you currently under the influence of any drugs, medication, or alcohol?
No.
Were you on a criminal probation at the time of this offense?
No, ma'am.
And do you understand if you're not a United States citizen, entry of a plea to a crime could subject you to deportation?
Yes, ma'am.
Okay, then to the charge of disorderly conduct, how do you wish to plead?
No contest.
I'll accept the plea, find you're entering it freely and voluntarily. I will withhold adjudication, give you credit for the
2 days.
2 days that you've served in the Orange County Jail. I'll order court costs and the filing fee. And I will give you 90 days to pay that. That's going to be $233, okay? All right. I release you as to this charge, sir. Okay, and good morning, ma'am. Could you tell me your name?
Susan Sharita Richardson.
Okay, Miss Richardson, you were arrested and charged with trespass on property. After warning, I've reviewed this. I do find probable cause, and I will appoint the public defender to represent you.
And Your Honor, I'd ask that you just stay the bond. I believe there's some I have some comp concerns.
Okay, and I will stay the current bond. And special conditions of your bond are that you not return to the property where this occurred, ma'am. Okay. Thank you. All right, good morning, ma'am. Could you tell me your name?
My name is Cynthia Perez.
Okay, Ms. Perez, you were arrested and charged with false imprisonment, domestic violence, tampering with a witness to hinder communication to a law enforcement officer, as well as battery, domestic violence. I have reviewed this. I do find probable cause on all three charges. I will appoint the public defender's office to represent you. Ma'am, you do qualify for pretrial release, which is a non-monetary release. However, it does come with conditions. If you violate the conditions, the non-monetary release will be revoked. Do you understand?
All right, the conditions are that you are to have no contact with the named victim in the case, that you not return to the scene, and that you possess no weapons. Okay,
And what if the scene of the crime is where I live? She doesn't legally live there.
I would just ask for a maintained separate residence, Your Honor.
okay. Maintain separate residences.
She would have to go back.
All right. The indication from the facts were that you both lived there.
Your Honor, in addition, can there be a one-time return in case the victim is there? So Ms. Perez can go somewhere else?
I just want to pick up.
Yeah.
Okay. And a one-time return with law enforcement to gather your property.
You're striking the no return?
It's no return except once with law enforcement to get her stuff. So,
Well, we have a 3-year-old child as well. I really would like to see my son.
ma'am, these conditions are going to be in effect. You have an attorney, and you can take it before the next judge if you want to alter these conditions, but I'm not altering them today. We need input from the other side, and we don't have that today. All right, good morning, sir. Could you tell me your name?
James Petty.
Okay, Mr. Petty, you were arrested and charged with aggravated battery on a pregnant person. I have reviewed this. I do find that there is probable cause. I will appoint the public defender's office to represent you, and I will set a bond in the amount of $7,500. Special conditions of the bond are that you have no contact with the named victim, that you not return, that you maintain separate residences, and that you possess no weapons, and comply with any DCF plan that is put in place. Anything else, State?
No, Your Honor.
Okay. You may return once to obtain your property, accompanied by law enforcement.
But you gotta go to law enforcement to get your belongings.
All right, good morning, sir. Could you tell me your name? Okay, Mr. Vasquez, you were arrested and charged with aggravated assault with a firearm, possession of a weapon by a convicted or firearm by a convicted felon, as well as battery, domestic violence. I have reviewed this. I do find probable cause on all of these. I will appoint the public defender to represent you. Sir, you're also currently on probation, and there was an on-view VOP based upon the fact that you're on probation and you got a new arrest. On the violation of probation, I will set that at no bond. You can take it before the judge who put you on probation to alter that. As far as the aggravated assault with a firearm, I'm setting bond in the amount of $10,000. Possession of a firearm by a convicted felon, I'm setting bond at $5,000. And battery, domestic violence, I'm setting bond at $1,000. Special condition is that you have no contact, and that you maintain separate residences, and you possess no weapons. Okay.
Your Honor, when he is released, could he have a one-time return with law enforcement? They do reside together.
One-time return with law enforcement to obtain your property, but currently is no bond on the violation of probation. All right. Good morning, ma'am. Could you tell me your name?
My name is Isidore.
Okay. Ma'am, you were arrested and charged with battery, domestic violence.
I have reviewed this. I do find probable cause, and I will appoint the Public Defender's Office to represent you. We're showing that you qualify for pretrial release, which is a non-monetary release. It does come with conditions. And we have input here. Okay, if we could swear in.
Raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Yes. Okay, lower your hand and state your name for the record.
One at a time, if you'll just come close to the microphone. Thank you.
Odesha Coggins.
Okay. State, would you like to inquire?
Yes, Your Honor.
We'll do it one at a time.
Good morning, Ms. Coggins. Can you please state your relationship to Ms. Kelcher?
My aunt.
Are you afraid of her?
No.
Has anything like this ever happened before?
No.
If anything like this or anything more severe ever occurred in the future, would you feel comfortable calling 911?
Yes.
And do you want to have contact with her while this case is pending?
No.
That's all I have, Your Honor.
And the next party? Is that the named victim?
Laquanda Joseph.
Did you say Miss Joseph? Okay. And were you just a witness to this incident?
Yes.
State has no questions, Your Honor.
All right, thank you. Okay. Ma'am, I am going to release you on pretrial release. Special conditions of your release are that you are to have no contact with the named victim or the witness in this case. Also, that you possess no weapons, and she does not reside there, correct?
I do not believe so.
Okay, and that you not return to where this occurred. Also, if DCF is contacted, that you comply with any DCF plan. That's all. I appointed the public defender. Okay. All right, thank you. All right, good morning, ma'am. Could you tell me your name? Okay, Ms. Gilkey, you were arrested and charged with battery, domestic violence, a first-degree misdemeanor. I have reviewed this. I do find probable cause. I will appoint the Public Defender's Office to represent you. And I will set a bond in the amount of $500 with the special conditions that you have no contact with the named victim, that you possess no weapons. Did they reside together?
I believe so, Your Honor.
That you maintain separate residences, can have a one-time return accompanied by police to obtain your property.
My son,
Excuse me?
my 1-year-old son, really much all I wanted to do was leave at the time with my son in a stroller. And she.
Stop talking about the facts. Don't talk about the facts.
Okay.
DCF was also contacted, Your Honor.
And that you comply with any DCF plan. Ma'am, for the time being, until I have more information, it's going to be a no contact, okay? Your case is assigned to another judge. You have an attorney. These things can be altered, but without any input from the other side, this is what we're going to have, okay? Thank you. All right, good morning, sir. Could you tell me your name?
Ezekiel Haywood.
Okay, Mr. Haywood, you were arrested and charged with battery, domestic violence.
Yes, ma'am.
Okay, it looks like we have some input coming here. All right, I have reviewed this. I do find probable cause. I'll appoint the Public Defender's Office to represent you. And so you're here on vacation from New York?
No, from Chicago.
Oh, from Chicago, okay. All right, State, do you want to make any inquiry?
Your Honor, can she be sworn?
Yes.
Raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name for the record.
Jasmine Marshall.
Good morning, Miss Marshall. Can you please state your relationship to Mr. Haywood?
Boyfriend.
I'm sorry?
Boyfriend.
Are you afraid of him?
No.
Has anything like this ever happened before?
No.
If anything like this or anything more severe ever occurred in the future, would you feel comfortable calling 911?
Yeah, but no.
And do you want to have contact with him while this case is pending?
Do I want to contact with him? Yes.
That's all I have, Your Honor.
Okay. Sir,
Okay.
I'm going to set bond in the amount of $500, and the conditions of your bond are that you have no hostile contact with the named victim in the case. You can have contact, but you can't have hostile contact. So if you start feeling angry, it's your obligation to walk away. Okay, go take a walk around the block, cool down. Also that you possess no weapons. And if DCF is involved, that you comply with any DCF plan. Anything else, State?
No, Your Honor.
Thank you.
Ravi is mental health.
I will waive the appearance, Your Honor.
Okay, on Ravi Iyer, I will find probable cause, appoint the public defender to represent him.
He does qualify for pretrial release. Given he has it looks like no convictions on his record, I would ask for pretrial release, Your Honor.
Has he been reviewed for mental health pretrial release, since he's in mental health right now?
Your Honor, they really don't. It's very rare that people get put on mental health pretrial release. I don't see any type of Baker Acts or anything. No mental health history. So I would ask for straight pretrial release in this case. You may get one person in months that'll qualify for mental health. You know why? Is he crazy?
Okay, I'm going to release him on pretrial release. Conditions: no contact with the named victim, no return. Maintain separate residence and possess no weapons.
Your Honor, I believe there's also an allegation of alcohol, so state would ask for no alcohol or drugs without a prescription, and DCF was contacted.
Okay, comply with any DCF plans and no alcohol or non-prescription drugs.
Are you striking the no return?
I'm doing maintain separate residence, can return once to gather his property with law enforcement. Got to be a shorter way to say that. More concise. All right, sir, could you tell me your name?
William Mitchell.
Okay, Mr. Mitchell, you were arrested and charged with battery, domestic violence. I have reviewed this. I do find probable cause. And I will appoint the public defender's office to represent you. And I'll set a bond in the amount of $1,000, special conditions that you have no contact with the named victim, that you possess no weapons.
No, batteries don't qualify.
And that you maintain separate residence. You can return once, accompanied by law enforcement to gather your property. But until we hear from the other side, you're maintaining a separate residence, sir. Good morning, sir. Could you tell me your name? Hey, Mr. Rooney, you were arrested and charged with battery, domestic violence. I've reviewed this. I do find probable cause. I will appoint the public defender's office to represent you. And I will set bond in the amount of $1,000. Special conditions that you have no contact with the named victim, that you possess no weapons, and that you maintain a separate residence. You can return once, accompanied by law enforcement, to obtain your property. That is all. All right. Good morning, sir. Could you tell me your name?
Brandon Tolliver.
Okay, Mr. Tolliver, you were arrested and charged with battery, domestic violence, as well as battery, dating violence. I've reviewed these cases, and I do find probable cause in both of them. I will appoint the public defender's office in both of them. Apparently, you qualify for pretrial release. And so I will release you on pretrial release with the following special conditions: that you have no contact with the named victim, that you maintain separate residence, that you possess no weapons. Okay. Anything else, State? Okay. All right. Good morning, sir. Could you tell me your name?
Antonio Bill Webb, man. Good morning.
Good morning, Mr. Webb. You were arrested and charged with assault, domestic violence. I have reviewed this. I do find probable cause. I will appoint the public defender's office to represent you.
Yes, ma'am.
And I will set bond at $1,000. Special conditions are that you have no contact with any of the named victims in this case, that you maintain a separate residence, and that you possess no weapons.
Yes, ma'am.
Anything else, State?
No, Your Honor.
These I'm going to need paperwork for. All right, sir. Good morning. Could you tell me your name?
Vergese Johnson.
Okay, Mr. Johnson, you were arrested on a Polk County warrant, and that warrant has no bond, so I'm going to stay the no bond status, and Polk County will come get you pretty soon, okay? All right, good morning, sir. Could you tell me your name?
Good morning, Your Honor. Johan Marin.
Mr. Marin, you were arrested on an Osceola County warrant. It has no bond, so Osceola will come pick you up pretty soon, okay? I'm going to stay that amount. I have to. All right, good morning, sir. Could you tell me your name?
Morning, ma'am. My name is David Allen, also known as David Carl Stephen Allen.
All right. Mr. Allen, you have a violation of probation in Judge Barber's court She signed a VOP for you and set you at no bond, so I will stay that amount. I will appoint the Public Defender's Office to represent you.
Thank you, ma'am. Thank you, Your Honor. Thank you, Your Honor.
Okay, thank you.
That's it, ma'am. Thank you. Thank you.
Good luck. Good morning, could you tell me your name?
Middlebrooks Jr.
I'm sorry, what?
Mark Middlebrooks Jr.
Okay, Mr. Middlebrooks. You are also here on a violation of probation out of Judge Calderon's courtroom. He set you at no bond. I'll stay the no bond status. I'll appoint the public defender to represent you. Okay. Good morning, sir. Could you tell me your name?
Ramon Romero.
Okay, Mr. Romero, you have a violation of drug probation under Judge Calderon, and he has set you at no bond. I will stay the no bond status and appoint the public defender to represent you.
Thank you.
All right, sir, could you tell me your name?
Vante Thomas Matthew.
Okay, Mr. Thomas, you have a violation of probation from Judge Strobridge. She set you at no bond. I'll stay the no bond status and appoint the public defender to represent you.
May I say something, please?
You can. I can't change your bond, though. Thank you. All right, good morning, sir. Could you tell me your name? Okay, sir, you were arrested and charged with robbery, sudden snatching. I have reviewed this and I do find probable cause. I will appoint the public defender to represent you. Do you have any paperwork on him? And also, apparently, you are on a probation currently. And I will appoint the public defender on a VOP. As to the robbery, sudden snatching, sir, I will set bond in the amount of $5,000. As to the violation of probation, I'm going to set you at no bond.
All right, Mr. Sims, you have two cases. The first one, I've already stated on record, it's a warrant out of Orange County for a failure to, I'm sorry, actually it's a VOP. And your bond is currently set at 0. Your second case is 2012 CF 5200. It's another violation of probation. Your bond is currently set at 0 at this time. All right, thank you. Timothy Amundson. All right, I have an out-of-county warrant from Polk County. It's for your failure to appear. Your bond is currently set at $500. Thank you, sir. Francis Chisholm. All right, so your warrant's out of Dixie County. It's for a violation of probation, and you have no bond at this time. Thank you. Shamiki James, 22 CF 2523. All right, good afternoon. I've reviewed the arrest warrant. Do find probable cause as to count 1, which is fraudulent use of credit card, $100 or more. Your bond's going to be stayed at $1,000. Count 2, which is the unlawful possession of stolen credit card. I do find probable cause your bond's going to be stayed at $500. You're not to have any contact with the listed victim, and you are not to return to the scene of the offense. Understood? Is that a yes? Yes. Okay, thank you.
The defendant currently has an out of McDonald's and was wondering if the bond could be lowered. The bond is a bit high for her.
Not at this time. You can file the appropriate motion.
Thank you, Your Honor.
You're welcome. Alice Triplett, 21 CF 2743. I'm sorry, 49. All right, it's a failure to appear, so your bond is currently set at 0 at this time.
I got a court date. Status hearing September 21st, 9 a.m. Courtroom 4F.
Edgar Colon Rivera.
I'm sorry, are these detoxing?
All right, would you like to waive his appearance?
Is it possible to reset it for tomorrow?
That's fine, we can reset. Ishmael Alexander Porter, 22 CF 2593.
Yes, Your Honor. Mr. Alexander Porter has a history of being found ICP in case 20 CT 580. The defendant was found ICP. His latest evaluation by Dr. Stavinsky was done on June 8th, 2022. And so we're wondering if he could be on a conditional release.
All right, State.
I'll leave that in the court's discretion, Your Honor. It does appear he has a history of mental health.
I am aware of Mr. Alexander Porter's competency issues. I'll go ahead and grant defense counsel's oral tenants motion for conditional release. The defendant is to stay out of trouble. He is to make sure that he's taking the appropriate prescribed medication by your doctors. You are not allowed to consume any illegal narcotics. You can only consume drugs that are prescribed by a licensed doctor. You're also not to possess or consume, possess any weapons or firearms at this time. Anything else, State?
No, Judge, that's all.
All right, thank you. Thank you so much, Mom. Stay out of trouble. Lindsay Barham, 22 CF 2594.
I do have a PCR recommended for this one.
Is that as to the burglary charge?
Yes, Your Honor. And also to the possession of controlled substance without a prescription charge.
All right, what is your argument as to the burglary structure unarmed, for the record?
For the record, Florida statute 810.02 says that it is a burglary under certain circumstances unless it's open to the public. And she was at Walmart, which is open to the public, so not able to do a burglary if it was open to the public during business hours.
All right, State?
The state concedes that there's not probable cause for that count, Judge.
All right. And your other argument was to count 3, possession of controlled substance, or something different?
Yes, Your Honor, with the possession of controlled substance without a prescription. I think that charge was for the fentanyl, and that is an illegal narcotic. It wasn't in the form of prescribed fentanyl, which is one delinquent.
I believe the possession of controlled substance without prescription was to the amphetamines, not the fentanyl.
1 second, Your Honor, let me. where it says it's for the amphetamines and not for the possession of?
Because she's already being charged for trafficking fentanyl 4 grams or more. So she was caught with 11 grams. She was also found in possession of methamphetamine. If you look and start with a large blue rubber band and it goes on to a small circular pill, they're talking about the amphetamine, so she's in possession of that. Okay? No worries. All right, so I have reviewed the charging document, and as to count 1, which is the petty theft second offense, I do find probable cause. Bond is set at $500. You're not to return to Walmart. Count 2, the state has conceded. The court does agree there's no probable cause as to burglary of structure unarmed. Count 3, which is the possession of controlled substance without prescription, which is the amphetamines, I do find probable cause. Bond is stayed at $1,000. Count 4, possession of use of drug paraphernalia, I do find probable cause. Bond is stayed at $500. Trespass, occupied structure, or conveyance, I do find probable cause. Bond is stayed at $5,000. As to the trafficking fentanyl 4 grams or more, I do find probable cause. Bond is going to be set at $50,000.
Your Honor, can we just clarify? You indicated as to count 5 trespass, bond would be stayed at $5,000. I have that the original bond amount was $500.
Did I say 5? Did I say 5,000?
Yes.
I'm sorry, 500.
Thank you, Your Honor.
The trespass. Count 2 ROR. Amber Brandstetter, 22 MM2042. Right, ma'am, you've been charged with battery, domestic violence. I do find probable cause. You do qualify for bonds with PTR conditions. Your bond's going to be set at $500. The conditions will be not to have any contact with the listed victim. You're to maintain a separate residence from that victim. If you have any personal items there, I will give you a one-time assistance with law enforcement to retrieve your items. You're not to possess any weapons or firearms, understood? All right, anything, State?
Nothing further.
All right, thank you, ma'am. Marie Caraballo Ruiz, 22 CF 2595.
She refused, but I'm gonna waive her appearance, Your Honor.
Okay, I will accept the waiver. I did review the charging affidavit. As to count 1, State, she's charged with child neglect without great bodily harm. Under statute, I thought you had to be a caregiver.
The state would argue that since they were residing together in the budget and that's identified in the police report for several days, she would be a de facto caregiver. The juvenile in this case was a runaway juvenile that had been missing for quite some time and then was residing with this defendant as well as several co-defendants that had been charged. And so the state's position would be, for purposes of probable cause, that that is sufficient to deem her to be a caregiver and not having sought aid for this minor victim for several different incidents.
Facto caregiver. Would you like to be heard, Ms. Clark?
Yes, Your Honor, I think that she is not a caregiver, and I'm not quite sure that what the facto caregiver would be under the circumstances, but she's not a caregiver, and that's clear about that.
I can certainly understand what the state is arguing as far as Ms. Caraballo being an adult in presence of a minor and having that obligation to report any criminal activities against a child should she become aware of such things. And because she, according to the charging affidavit, was aware of such abuse and she failed to report, the court will go ahead and find probable cause as to count 1. Bond will be stayed at $1,000. As to the possession or use of drug paraphernalia, court does find probable cause. Bond will be stayed at $250.
Yes, I understand you made your ruling, just for the record, I just want to state that she didn't
All right, thank you, Ms. Clark. Your objection is also noted for the record, and obviously you all can do a motion if she has the public defender's office assigned to her case.
Your Honor, there's no contact on this?
Yes, no contact with the co-defendants, no contact with the listed minor child. Corey Dixon, 22 CF 2596. It's going to be the same issue as to count 2.
And the state also concedes there's no probable causes to count 2, Judge.
All right.
I also have a possible PC argument for count 3.
For trespass?
Yes, the previous trespass, most of the trespasses in Osceola County expire within 1 year. This was in past the 1-year mark, and I don't see anything within the 4 corners that said that this trespass lasted more than a year.
That sounds like a very, very good argument for a motion to dismiss, Ms. Clark. All right, sir, I have reviewed the charging affidavit as to count 1, petty theft, second offense. I do find probable cause. Your bond is going to be stayed at $500. Please do not return to the Walmart. Count 2, you're going to be ROR'd. Count 3, which is the trespass, court finds probable cause. Bond's going to be stayed at $500. All right, anything from the state?
Nothing further, Judge.
All right, thank you. Glenn Flowers, 22 CF 2597. I will waive the formal reading of the charges, Ms. Clark. And Ms. Clark, for the record, the court received a motion for pretrial detention. Madam Clerk, do we know which judge this is set in front of?
It's assigned to Judge Young, Your Honor. I did check and benchmark prior to initial appearances.
All right, thank you. And Ms. Clark, I take it you've not had an opportunity to review the pretrial detention?
No, Your Honor.
All right.
Just for the record, Your Honor, I did email it to the PD supervisor, Ms. Crystal Broadway, so that she can forward it to the appropriate assigned assistant public defender.
All right, this is what we are going to do. As to case 22 CF 2597, the court has reviewed the charging affidavit for all counts. I do find that there is probable cause for each count. I also find that proof is evident, presumption's great. With that being said, this case needs to be set for a motion for pretrial detention hearing in front of Judge Young as soon as possible. Bonds will be 0 for count 1, 2, 3. As count 4, bond will be set at
count.
Well, do you want, is it 0 bond for all? That's what you're requesting, State?
Well, specifically, count 4 is a dangerous crime that we included in the motion for pretrial detention, the child abuse, so we are asking for it on that count.
Okay, so I missed that one. Okay, so that's going to be 0 as well. And State, what do you say as to the failure to register as a convicted felon?
He's entitled to a bond on that, Your Honor.
The bond's going to be set at $1,000.
Thank you, Your Honor. I'll let my office know about the hearing.
Counts 1, 2, 3, 4, 0, and count 5, which is the convicted failure to register as a convicted felon, is going to be $1,000. Okay. Absolutely no contact with the listed victim, no contact with co-defendants, no possession of weapons and firearms, no illegal consumption of any drugs, and no return to the budget inn. Located at 4686 West Earl Bronson Memorial Highway. All right, thank you. Darian McBlaze, 22 MM 2045. All right, sir, you've been charged with battery, domestic violence. I've reviewed the affidavit. I do find probable cause. Do qualify for bonds with PTR conditions. Bond set at $500. Conditions not to have any contact with the listed victim. You're to maintain a separate residence at this time from the victim. If you have any personal items at the home, I'll give you a one-time assistance with law enforcement to retrieve those personal items. And you are not to possess any weapons or firearms. Understood? Thank you, sir. Jose Rodriguez, 22 2046, 22 1362. Review the charging affidavit for false name or ID by arrestee. I do find probable cause. Your bond's gonna be stayed at $500. As to case 22 1362, it's a failure to appear. And it looks like you do have a bond, and that bond is set at $500 as well.
Have a court date. Is he still in jail September 15th?
Go ahead, put it on the
Is he
record.
still in jail September 15th, 8:05 a.m., courtroom 5B? If bonded, arraignment September 28th, 8:30 a.m., courtroom 5B.
It's Cecile or Cecilia Center, 22 2047, 21 CF 2938. For the 2047 case, false name or ID by the arrestee, I do find probable cause, bond is stayed at $500. She has another case, which is 21 CF 2938. It is a bench warrant. It's 6 separate counts. As to count 1, bond is set at $1,000. Count 2, bond is set at $1,000. Count 3, bond is set at $1,000. Count 4, bond is set at $1,000. Count 5, bond is set at $500. And conspiracy to commit, which is the last case, it's set at $500 as well.
I have a court date, that is hearing September 21st, 9 a.m., courtroom 4F.
Did you get, I'm sorry, I'm not sure, was there a bond for the false name or ID or $500?
500, yes. John Swift, 22 CF 2598, 22 CT 3025. All right, Mr. Swift, your first case is in reference to grand theft of a motor vehicle. I do find probable cause for this offense. Do not qualify for PTR. Your bond set at $3,500. You're not to have any contact with illicit victim. You're not to return to the scene of the offense. You're not to possess any weapons or firearms. As to 22 CT 3025, which is driving with a suspended license, I do find probable cause. Your bond is going to be set at $500. Please do not drive unless you obtain a valid driver's license. Thank you.
If he's still in jail September 15th, 8:05 a.m., courtroom 5B. If bonded, arraignment September 29th, 8:15 a.m., courtroom 4A.
Gordon Parenza, 22 CF 2599.
I have a PC argument for this one.
Which count, ma'am?
Count 2.
Okay.
The burglary. Within the foreground of the affidavit, I do not see anything that shows that he burglarized the car. It might show.
And how did he get in?
But it doesn't show anything that he was even in the car. He may have been in possession of the credit cards afterwards, but those have been found on the street, purchased on the street, but there's nothing that actually ties him to the burglary being inside the car except for the possession of the credit cards, but that's not the burglary. And the conveyance that is the possession of the credit card.
State?
I'll leave it in the court's discretion. I think we have a pretty good charge on the other counts, so I'll leave it in your discretion.
All right, as to count 1, which is the petty theft, do find probable cause. Bond is going to be set at $500. Actually did find PC on the burglary of a conveyance. And the bond is going to be set at $2,500. He's not to have any contact with listed victims, not to return to the scene of the offense.
Thank you.
Otis Davis, 22 CF 2567. We heard this case yesterday.
Yes,
There was a
Your-
PC argument as to count 4 and 5.
And Your Honor, if I might approach, my colleague just brought over a supplement that was sworn to, and I apologize to the defense that I don't have a copy for them. Because it was
We're unable to hear Your Honor.
I
So-
apologize.
State just provided me with a supplemental report. They apologize for not getting it to you because they just received it. Just give me a second. All right, so the issue was possession of drug paraphernalia. There was 2 counts, and I found probable cause for the first possession of drug paraphernalia, but not the second. So this supplemental just says that they found narcotics in the back seat of the vehicle after removing the subject. So it doesn't tell me what the paraphernalia is.
Yes, Your Honor, my understanding was there was also no probable cause for count 5, introducing contraband.
Well, I do, well, now I find PC for that.
Okay, and I do agree with the court that there is not sufficient information on the supplement for the possession of drug paraphernalia in count 4.
All right, so count 4, you're gonna be ROR.
And Your Honor, if I may, count 6, possession of a controlled substance without a prescription. I didn't see any prescription medicine again listed in the original statement, but you might see it in your supplemental.
I found PC for that yesterday, and
I was all methamphetamine.
let's see. Yeah, so the possession of controlled substance without prescription, I found PC and bond was set at $500. And it was for the methamphetamine. Because I believe your colleague was arguing about the residue not being sufficient for possession. That was his argument, and I told him that there's plenty of case law with residue being sufficient for possession. So I noted his objection for the record, but found PC and then lowered the bond amount.
That may be his argument, but my argument would be that doctors don't prescribe them. They do prescribe something called doxostin, but DOSXYN, but that's like a small blue pill. It's not a street narcotic. Methamphetamine.
And again, I think that's a great argument for motion.
All right, thank you, Your Honor.
You're welcome. All right, so as far as count 5 is concerned, I do find probable cause in that bond is going to be set at $1,000. All right. Well, it's not my last case, but we have an out-of-county warrant. It's for Victoria Antozowski. Oh, Leon, gave him a whole, what's the name? Morgan? I'm sorry, Morgan Victoria Antozowski. Hold on, this is for Otis,
Otis Davis.
all right, so Mr. Otis Davis, his bond as to count one, which was the battery, was 500. The possession of used drug paraphernalia was 500. False name or ID was 500. The other possession, as I told you, we're gonna ROR. Introduction, contraband, it's 1,000, and then possession, controlled substance without prescriptions, 500.
Okay, thank you, Your Honor.
Was that with PTR, Your Honor? I think you said yesterday.
Yes, it was with PTR. The conditions: no contact with the victim, no weapon, no firearms, no consumption of any illegal drugs. So I don't need this. So where's our,
Okay, for the record, today is September 6, 2022. This is the 1:30 afternoon calendar. My name is Brad Gardner. I'm going to be the presiding magistrate court judge over this matter. This is position 9 on my calendar, Dominic Ponder versus Carl Pierre. Mr. Ponder is represented by Mr. Spoo. Mr. Pierre is represented by Mr. Hyman. Mr. Spoo, I'm going to ask you to swear in your client in a minute and then present your case. But give me just a brief synopsis of what you believe this case is about.
Yes, Your Honor. So my client, Mr. Dominic Ponder, he was, it was just an average day for him. He was a passenger in the vehicle of Rock Erickson. He cannot drive, so he was using a ride share. The vehicle he was in made a controlled stop, and the defendant in the matter, Carl Pierre, did rear end the vehicle that my client was in at the time of the accident.
Okay, Mr. Hyman.
Yes, Your Honor. And I'm looking at the accident report, and the vehicle that Mr. Ponder was riding in was cited for not having proper tag. And from my understanding from the report, because it didn't happen to have a diagram, that it was kind of like stop and go traffic. And so that to the extent that Officer Pierre made contact with the vehicle that Mr. Ponder was riding in, it would have been a tap. And according to the narrative, there was asked whether there were not any injuries. There was reported no, but then later on, I think Mr. Ponder changed his mind and wanted some degree of medical attention. Where we are today, and I've kind of discussed this with Mr. Spoo, is that I looked at the complaint and it's deficient in some matters that I'll bring to the court's attention. And through some divine gremlin or whatever like this, the complaint didn't make it through the proper channels to where it should have, so that we're really looking at damages today more so. There's possibly some other issue that I can raise, but primarily damages in this case. And so I plan on bringing to the court's attention my the law as it relates to Mr. Ponder testifying about any perceived damages, things of that nature. But that's kind of the long and short.
Okay, so when you say that, is there going to be any question as to liability?
There may be a technical question as to that, Your Honor, that I'll raise depending on how Mr. Smooth presents his case.
He's putting a lot of pressure on you, Mr. Smooth, Mr. Spoo.
Well, Your Honor, I just kind of want to clarify in terms of today. It's my understanding that we were coming to testify as a default damages on hearing, not a evidentiary trial. And I just want to clarify that.
Let me see.
Because we moved for default back in November of 2021. I know we've been following up with Your Honor accordingly throughout that period of time. We submitted a proposed order for default and we continued to follow up, and the court asked for us to submit any type of evidence relating to damages in regards to this trial, not so much towards liability or a evidentiary trial in general.
Okay. I'm looking at the motion for default judgment. Looks like it was filed November 30th of 2021.
And Your Honor, while you're looking for that, if I could speak, from my understanding, even if you're looking at a damage situation, unless they're liquidated, then you have to have evidence on damages.
Yes. Yes, you have to hear evidence and testimony as it relates to establishing damages, not easily ascertainable.
And that's just what I wanted to bring to your court's attention, because it sounded like defense counsel is coming in that I need to prove our case as it relates to liability and things in those regards. And I just wanted to bring to your honor's attention that we're here today on a hearing for unliquidated damages.
Your Honor, and here's why I kind of had the conversation with Mr. Spoo. With the city of South Fulton and being a city of South Fulton police officer in his official capacity, then he has what is called official immunity. And I don't know how many cases the court may have dealt with in this regard, but neither the city nor Mr. Can waive that immunity. That immunity is waived to the extent that somebody needs to mute it.
Yeah, I'm gonna.
That immunity is waived only to the extent that it is shown that the city has purchased insurance. But before you even get to that, you have to properly plead that you have given the city an item notice. I raised that issue to Mr. Spoof offline, that I didn't see anywhere in the original complaint that they alleged they comply with an item notice. So that is something that we can't waive. And that was a defect in the original complaint that I brought to this attention.
So it's the allegation, again, and correct me if I'm wrong, but that's why I ask these questions, so I can get the four corners of the issue understood. Mr. Well, let me ask this question, and then someone is requesting my help in the other case. Is the allegation that Mr. Pierre was on duty at the time?
Yes.
And he was driving
a city of South Fulton police car.
Okay. Let me look at this, what this issue is, but I'm going to come back to you, Mr. Spoo. When I come back, I want you to address that issue with me as it relates to individual versus municipality.
Understood, Your Honor. Again, I just would like to state that, we filed this lawsuit in September, moved for default in November, and counsel showing up today at a hearing on damages and making these arguments. And I just wanted to express that, Your Honor.
No, and I understand, and my understanding, I could be wrong, and that's why I'm bringing it to your attention so we can address it, is that from a situation of damages, if he was acting within his capacity as a police officer and he caused an injury to anyone in public, wouldn't the municipality be the appropriate person to sue?
Well, based on their police report, it doesn't specifically indicate that he was acting under his employment. It just says he was driving the vehicle. And as I'm sure you're aware, Your Honor, you could be off duty driving your police car.
Which is going to be the other issue that I was going to address, which is the jurisdiction, if we're here, if it was, jurisdiction is based upon where Mr. Pierre lived, or is based upon where the incident allegedly took place. So let me see what Mr. Wetzel is asking for, and then I'll come back, okay?
Thank you, Your Honor.
You're welcome. I'm sorry about that. Miss Mary, just for the record, positions 7 and 8, they've reached a consent agreement. They're gonna need time, possibly by the end of this week. They believe that the case can be resolved in line with what we did before. I told them that we'll continue the case out for a month, and they should send, we'll continue the case. Excuse me, they should send the documents to you for my signature, and then that'll get filed and the case will be dismissed.
Okay.
All right, so Mr. Spoo.
Yes, Your Honor.
I believe I ended on the question about, even from a damages standpoint, whether, and Mr. Ponder, I'm gonna place you on mute again, sir, because whatever you got going on in the background is distracting. Thank you. Mr. Hyman, are you there?
I am, Your Honor. I am, Your Honor.
Okay. So, the question about assuming we're only here talking about damages, is Mr. Pierre the proper party? And I think I know the answer, Mr. Hyman, but I'm asking this to better educate myself. But go ahead, Mr. Spoo.
So, Your Honor, I think where we're at, again, is the police report doesn't indicate whether Mr. Pierre was on or off duty at the time of the accident. If he's off duty, he doesn't have any type of immunity. We served him in Ellenwood, which would be in Clayton County, which is where we are right now. The defense did not file an answer. They didn't file an objection. They didn't file a motion to transfer venue. They didn't file anything related to this lawsuit. We've been waiting since September. We filed the default in November. And again, counsel's coming in here in September of 2022. And now all of a sudden stating that his client was on duty.
Your Honor, if I may respond, it's the reason that I'm even here in September. That's because, and that's what was my opening salvo, is that due to no fault of my own and from talking to Mr. Pierre, but for getting Nelson Nice, I wouldn't even known about this. And so I started working for and I told this to Mr. Spoof, for the city of South Fulton on February of 2021. And in some shape, form, or fashion, his lawsuit that was served on him got lost in the shuffle, didn't make it to me in my office or ultimately to anyone else. So that's why I did the opening as I did, but that's still under 3633-1 doesn't Mr. Pierre nor the city can waive its immunity. And so that being the case, and also, and that's what I was looking for when I was offline. There's also in the statute that to the extent that you are in that case suing a police officer in official capacity, then the proper party would be the city and not the officer. But I was just trying to find that statute. But I know there's a recent case and statute for that stands for that proposition. And Mr. Pierre is here on the line. He was on duty. He could testify that if the court wants to hear that from his mouth, but that's my understanding.
Where's that sound keeps coming from? So my understanding, frail as it may be, is that I'll apply, well, if Mr. Pierre was off duty, and I'm asking this question to you, Mrs. Spoof. If Mr. Pierre, let's say he was off duty, but he was traveling from work to home, would that change your position?
I mean, at the end of the day, Your Honor, we don't, there's no discovery in magistrate court. So first of all, we don't know that at the time of filing suit. We don't know that period. And I don't think that it would change my understanding if he, again, we don't have any testimony or anything related to this gentleman being on duty, coming home, or whatever it is. We don't have any of that. And again, we're here not on liability. We're not here to take Mr. Pierre's testimony in regards to evidence and what he's going to be arguing whether he was or was not. We're here today on a hearing for damages for them being on default.
Okay, I apologize, Mr. Spoof.
No problem, Your Honor. I think we lost you there.
Yeah, you did. I was like, you're freezing, Mr. Spoof. And then turns out it was me.
Oh, goodness. Did you hear everything that I had said, Your Honor, or do you need me to repeat what I said?
I think I lost you at the point of saying your argument would be the same.
Yes, Your Honor. What I was stating is, I believe at this point in juncture, my argument's the same. We don't have any testimony regarding Mr. Pierre's capacity that he was on that day. And based on the police report, it doesn't say. And we're not here today on an evidentiary hearing where Mr. Pierre is testifying about anything related to the trial. We're here today on hearing on damages. So that was the argument that I'm making, is that we're here to argue my client's damages, not here to have Mr. Pierre testify whether or not he was on duty that day or whether or not he was coming home that day. We're kind of just coming up with hypotheticals at this point.
And that's,
if I may speak.
1 second, Mr. Hyman. Yes, you will be able to speak, but 1 second. And that's a fair point. Theoretically, again, is helping me. Honestly, this is exercising brain muscles that I haven't exercised in a long time. So I'm loving this conversation. Let's say you sue Mr. Pierre and Mr. Hyman is certain that you're basically in the wrong venue.
Mm-hmm.
He can do a limited entry or he can just ignore it and come back later and say, well, yeah, you sued me, but you didn't prove that you're in the proper venue to be sued. So, and I am not making judgments on any of this stuff. I'm asking these questions because I'm trying to figure this out so I can be fair to both sides. Go ahead, Mr. Hyman. Oh,
I was trying to find the case I was looking for. Your Honor, you're on the right path because no matter whether or not the damages or not, the real or proper party and interest is always an issue in the case. That's not waived. So you are correct. And it's by statute now that when you are suing a police officer, other official in the capacity that the true party would be the city. And when I use work city, land, all places like that, they generally do the distinction between official and sovereign and these kind of different immunities that are put out there. And one of the issues by statute, i.e. the Constitution, and it's 3633-1, is that Mr. Pierre, in or whoever in their oversight of getting a complaint, they can't waive the sovereign immunity of the city. And so to the extent that the city is the proper party, that is not waived. And so I think your honors are on the correct path. Also, I pointed out to Mr. Spo, just looking at the complaint, that there's other defects in it as it relates to the proper in-litem notice. So I think, and I had mentioned this to Mr. Spo about him maybe perfecting that, but he indicated that he wanted to proceed today. So that's kind of where we are in my perspective. And we could do a bench brief on it if you like, Your Honor, but that's just something that I'm just kind of talk to Mr. Spo about.
No, and that's what I was going to say, is that I'm going to accept evidence today, but I'm going to withhold judgment because this is something that honestly I'm going to have to look into a little bit more because I don't know the answer.
And Your Honor, just to kind of piggyback, I do think that maybe that's the best route. And the reason being is, again, whether, currently the complaint is set out against Mr. Pierre and he has his own insurance, correct? And, the proper avenue would be to move forward with testimony on damages. And today is not the proper avenue to make an argument. If counsel wants to make the argument, he's essentially making an argument without testimony, and he can't have any testimony today from Mr. Pierre regarding his status of on duty or off duty. So I just wanted to add that, Your Honor.
I don't think that's correct, Your Honor.
I mean, and the thing is, I can hear whatever evidence I want to hear, and I'll take your objection under advisement, Mr. Spoo, and at the appropriate time, I'll decide whether that is a relevant issue here. But I think, given kind of what I've heard so far, it would be appropriate to get more evidence than less evidence, because, I mean, this is most likely will be appealed or could be appealed, and I want there to be a record of everything that is taking place, because even look at Mr. Pierre. At some point, if I rule against Mr. Pierre may have an argument of bringing City of South Fulton in to say that they're responsible for covering this, or they have an insurance policy to cover this. But looks like we have two talented lawyers and capable of earning an income as it relates to this case, because I somebody's going to be responsible, and we'll go there. All right, so Mr. Spoo, we're going to deal with the issue of damages. And so I want you to call your first witness and swear your witness in.
Thank you, Your Honor. At this point, I'm going to be calling Plaintiff Dominic Ponder. Good afternoon, Mr. Ponder. Can you raise your right hand for me? You swear to tell the whole truth, nothing but the truth, so help you God?
I do.
Okay, let me stop you, Mr. Spoo.
Go ahead.
Mr. Ponder.
Yes, sir.
From the beginning of this hearing to where we are now, it looks like you've changed the name. As
I don't know. I already have a Zoom account, and I don't know if it's logging me in and out. But you see, I've been in and out of the meetings.
okay, I'm going to change the
My
name
name
of
is Dominic Ponder.
I'm going to change the name of Mr. Ponder. That'll just help me, because I can see the name, and then there's no way in the world I'm going to call you Mr. Verse Rare or whatever it said. Go ahead, Mr. Boo. I'm sorry.
No problem, Your Honor. Thank you for your clarification there. Mr. Ponder, we're here today regarding an accident. Do you remember being involved in an accident on September 27th of 2019?
Yes, sir.
Okay. Were you a passenger in the vehicle at that time?
I was.
Can you demonstrate for the court where you were sitting in the vehicle at the time of the accident?
I was in the back seat behind the passenger.
Okay. And where were you traveling at that time?
I know I lived on Terra Boulevard. I was going towards the strip club Rumors.
Okay. And was that road, Jonesboro Road Southeast coming to I-285 East? Does that sound accurate to you?
Yes.
Okay. Did you ever know the driver of the vehicle you were in prior to this accident?
I don't.
Okay. And can you tell me, was your vehicle that you were in, was it stopped at the time of the accident?
Yes.
Okay. And the defendant is present, Carl Pierre. Do you recall his vehicle making contact with the vehicle that you were in at the time of the accident?
Yes.
Can you describe for the court on a scale of 1 to 10 what you felt the impact of the collision was at that time?
Really at about 7.
Okay. So it's your testimony today that you felt that the impact was a 7 out of 10, correct?
Yes.
Okay. Can you tell me the way that your body may have moved in the vehicle at the time of the accident?
I was sitting straight up, but it didn't take, like, it was a regular 4-cylinder car, so it wouldn't take much for, like, my legs are long, so it didn't for it to touch the back of the passenger seat.
Okay. Did any part of your body make contact with the vehicle you were in after the accident occurred?
Say that one more time.
Did any part of your body, while you're in the vehicle you're in, make contact with any part of the vehicle?
Yes.
After the collision or the impact occurred?
Yes.
Okay. What part of your body was that, and what part of the vehicle did it make contact with?
My leg against the chair.
Okay. What leg was that? Do you recall?
It was both of them.
Okay. So the accident occurs. Did you feel any pain after the accident occurred?
I just had whiplash, and I didn't really feel my pain until afterwards.
Okay. Can you describe what you mean by you had whiplash?
Like just blurry vision, kind of a minor headache.
Okay. Did you happen to take any emergency medical transportation after the accident occurred?
Yes, I went to Grady.
Okay. When was it that you took the emergency medical transportation?
From the scene.
Okay. And you went to Grady Hospital, correct? You went to Grady Hospital, correct?
Yes.
Was there a reason you went to Grady Hospital?
Yes, because I was having blurry vision, and then being albino, if that can lead to pretty much complete blindness if the impact is,
may I object to?
I understand your objection. So, Mr. I'll let both sides know. There are certain words that come in my ear and go out the other. I understand that unless you can set a foundation that Mr. Ponder has medical training to testify to the things that he's testifying to, it's just going to go in one ear and out the other.
Understood, Your Honor. Mr. Ponder, just specifically as it relates to your ambulance, I think my question just was there a reason you went to Grady instead of another hospital?
They said because I was asking about my head, I would have to go because of trauma.
Okay, so the EMT.
And let me stop you, Mr. Spoo.
Yes, Your Honor.
So it wasn't your choice to go to one hospital versus another hospital. That was a decision that was made by the personnel.
So, Your Honor, so he wanted to go to a different hospital that was closer to where he lived, and they specifically told him he had to go to Grady because it was a trauma center.
I know Grady's level 1 trauma center, and I get it, but that's what I was trying to understand. Is based upon your question, it seemed like he was making a choice as to where he went.
No.
But it sounds like you're saying that it was a decision made by medical personnel on the scene.
Correct, Your Honor.
Thank you. Go ahead, sir.
Okay. Do you recall what pain that you were having, Mr. Ponder, at the time that you arrived to Grady?
Just a minor headache and eventually my leg.
Okay. What leg was that?
My right leg, to be exact.
Okay. What kind of pain were you having to your right leg?
Just different aches.
And you left Grady that day, correct?
Yes.
Okay. Were you given any medication?
I believe while I was there, yes.
Okay. Were you given any type of pain medication or muscle relaxers?
Yes. I can't remember exactly what it was.
Okay. So you after that you were released from Grady, correct?
Yes.
Did you end up seeking further medical treatment after that?
Yes.
The next day on September 28th of 19, do you recall going back to Southern Regional, or strike that, do you recall going to Southern Regional Medical Center?
Yes, sir.
What was the reason you went there?
I was still feeling my leg aches.
Okay. And was that in your right thigh?
Yes.
Were you still complaining of headaches at that time?
It was more of my leg than the headaches by that time.
Okay. Did you receive any type of medical recommendations from Southern Regional Medical Center when they discharged you that day?
Your Honor, I've been a little kind of lenient on some of the leading and the hearsay.
Staying at the hearsay, leading, I generally gauge it on moving the process along. So I will pay attention to it. So I'm gonna sustain the hearsay, overrule on leading.
Mr. Ponder, so you were discharged, or strike that. Mr. Ponder, were you discharged from Southern Regional Medical Center that day?
Yes.
Did you end up seeking any further medical treatment after you left Southern Regional Medical Center?
Yes, I did treatment at Southern Crescent, I believe it's called.
Southern Crescent. And how long after treatment with Southern Regional Medical Center would you think that you went to Southern Crescent?
I believe it was within a week.
What kind of treatment did you receive at Southern Crescent?
It was different ones. Names to be exact.
Was it chiropractic treatment?
Yes.
Sorry, what?
Your Honor, that's leading.
He didn't understand.
I didn't understand the question.
Okay, do you understand the treatment you received?
I went to the chiropractor.
Okay.
I just didn't know the exact name of the particular treatment they did.
Okay. And if you don't know an answer to a question, say, I don't know the answer. Okay, go ahead, Mr. Spool.
Thank you, Your Honor. Do you recall how many times approximately that you sought treatment with Southern Crescent?
I don't remember the exact amount, but I know I did. I went a couple times for at least almost 2 months, I want to say.
Okay.
Sorry, Mr. Corner, I didn't understand that.
For about, I want to say it was about 2 months. I'm not sure the exact number of sessions. I can't remember right now. This was about over three years ago. So
Mr. Ponder, you first started treating with Southern Crescent, and would you agree with me that your final treatment date was November 27th of 2019?
That's correct.
Okay, so that was approximately 2 months exactly from your data accident.
Correct.
Were you having any pain in any areas of your body after your final treatment with Southern Crescent?
A little bit, not too much.
Okay. Do you feel that the treatment that you received at Southern Crescent helped with the injuries sustained from the accident?
I wouldn't say 100%, no.
Okay. Why do you say that?
Just because I was still, feeling minor pains afterwards.
Okay. Mr. Ponder, I want to discuss with you your medical expenses related to this accident. Would you agree that your total bills from Grady EMS were $1,969.25?
Your Honor, I object in terms of the improper foundation.
Your Honor, I have submitted to you our medical bills in regards to this hearing. So I'm just expediting the process for Your Honor. If you would like me to pull up the actual bills themselves, and if counsel wants me to take the time to do so myself, I'd be more than welcome to.
I can say that you can ask, did he incur bills or expenses as related to this accident? And if so, can he specify the amount of those expenses?
Understood, Your Honor. Mr. Ponder, did you end up having any medical expenses related to treatment you received after this accident?
I did.
Did you receive any type of medical expenses from Grady EMS?
Yes.
Do you recall the amount of the bills from Grady EMS?
I'm not by memory, but I'm pretty sure I have it in my documents.
Would you have any reason to disagree that the total bills were $1,969.25?
Objection, Your Honor. That's counsel testimony, not the witness.
Okay, so Mr. Spool, you have submitted these documents, and I don't necessarily need to hear it out of the witness's mouth as to whatever are the alleged damages. So we can move past that.
Oh, understood, Your Honor. Mr. Ponder, do you recall having medical expenses related to Grady Hospital?
Yes.
Do you recall having medical expenses related to Emory Medical Care Foundation?
Yes.
Do you recall having medical expenses related to Vulcan Imaging Associates?
Yes.
You recall having damages related to Southern Regional Medical Center?
Yes.
Do you have any understanding of medical bills related to Southern Regional Medical Group ER physician?
Yes.
And did you have medical expenses from Southern Crescent?
Yes.
Do you, can you tell me about how this incident has affected your life?
I'm a music artist, so I had to stop doing shows at the time. And I was also promoting the strip club Rumors. I was doing there Tuesday nights. I was actually on the way there that day.
Okay. So you were employed at the time of this incident,
Yes, sir.
and it affected your ability to promote and work after the accident occurred.
Yes, sir.
How has this incident affected your life socially, if at all?
I'm just more cautious about the transportation I choose. And just being more aware. It's just making me be more aware.
I'm sorry to interrupt. You can finish. I'm sorry, Mr. Ponder.
No, that was it.
Okay. Have your injuries inhibited you from performing any type of daily activities?
Now, no, but then, like I said, I had to stop performing in general as an artist. So it was a period of time where it did.
Understood. Other than headaches and pain to your right thigh, did you experience any other pain related to the incident that you were involved in?
No.
Do you have any reason to believe that any of the injuries or pain that you've discussed are related to anything other than the accident you were involved in?
Your Honor, I object to that.
Sustain. Go ahead, Mr. Spooler.
Thank you, Your Honor. Did you have any pain prior to the accident, Mr. Ponder?
I didn't.
So on the day of the accident, the second before the accident occurred, did you have any pain in your right thigh?
No, sir.
Did you have a headache at all prior to the accident?
No.
After the accident occurred, you had a headache?
Yes.
And after the accident occurred, you began to have right thigh pain?
Yes.
I don't have any further questions, Your Honor.
Before you start, Mr. Hyman, Mr. Ponder,
Yes, sir.
did you have a fracture of your thigh before?
Yes.
So you have experienced pain before this accident in your thigh?
Yes.
Okay. Go ahead, Mr. Hyman.
Thank you, Your Honor. Mr. Ponder, my name is Vincent Hyman. I'm here on behalf of the City of South Fulton and Sergeant Pierre Call. As it relates to the date of the accident, can you see Mr. Pierre on the monitor, course monitor?
You're asking me if I can see him?
Yeah. You recognize him?
When he was on the camera, yes.
Can you see him? Can you see him now?
I only see you right now.
Okay. But you saw him earlier today during the conference?
Correct.
Okay. On the date of the accident, did you see him on that date as well?
Yes.
Was he in uniform?
Objection, Your Honor, outside the scope of prior testimony.
I'm gonna overrule it. I'm gonna let him go into this.
Was he in uniform?
Yes.
Okay. And you said you were a backseated passenger?
I was.
Were you a belted passenger?
Objection, Your Honor. Irrelevant.
Go with the damages and mitigation.
That's what I was gonna ask, Mr. Spook.
I was objecting in regards to the evidentiary rule that whether my client's wearing a seatbelt is irrelevant.
Okay, I'm gonna overrule it. You may answer the question, Mr. Ponder.
Yes.
If you were wearing your seatbelt, what part of, what caused your headache? Did you hit your head on anything?
I didn't hit my head on anything, but my neck did snap forward.
Okay. And did you step outside the vehicle after the accident?
Yes.
Okay. Do you know whether or not a tow truck had to be called for the vehicle that you're riding in?
I'm really not sure.
Well, let me ask this way. Did the vehicle appear to be drivable?
I'm not sure, sir. I don't even drive myself. I was just a passenger.
Okay. Now, I'm going to briefly, I'm gonna pull it up on the screen. If I can here. You won't be able to see it, but I can. You indicated that you went to Grady by EMS, correct?
Yes.
And your chief complaint was what, right leg pain and headache?
Yes.
Now, what, if any, treatment did they do when you were on the way to the hospital for Grady EMS?
I cannot remember the treatment, but I know it was for my my neck.
Okay. Once you got to the hospital, what, if any, treatment occurred there at Grady Hospital?
That's what I'm saying. I don't know I'm not sure exactly what it was, but I know it is pretty much checked my head.
Well, let me ask you this. Did they do any type of CT scans?
At Grady, no.
Did they give you any hot or cold compacts or compressors at Grady?
I want to say they did. I can't remember right now, to be honest.
Okay. And do you recall the type of medication they may have given you, if any?
I can't.
Okay. Where was the next place that you sought medical care?
Southern Regional.
And what, if anything, did they do for you there?
I know they had checked my head as well, but my leg, and they had did a scan on my leg as well, on my thigh, my right thigh.
And is this the same one you previously injured?
Yes.
And when you say scanned, do you know if it was an X-ray, MRI, CT scan?
I can't remember if it was an X-ray or MRI. It was one of them.
Do you recall any other treatment you may have received at Southern Regional?
Honestly, I would have to look at my documents to just refresh my memory of what I did that day.
Do you
Mr.
remember?
Ponder, I think the question was, do you recall any of the treatment? And it's fine if the answer is no. It's fine if the answer is yes. But saying I have to check my records.
Of my memory right now.
Okay. Go ahead, Mr.
Okay.
Hyman.
Did you seek any further medical treatment after Southern Regional?
Yes, that's when I went to the Southern Crescent.
And what, if anything, did they do for you at Southern Crescent?
I had sessions with the chiropractor.
When you say sessions, what would that entail?
Treating my right thigh, and also I want to say my neck.
Okay.
His question is getting at what did they do? Not like where did they treat, but was it ice? Was it warm?
No, it
contacts?
it was more than ice. It was I'm just not sure what the proper term is, but it was machines that pretty much worked the area of where the pain is.
And Mr. Ponder, during your medical treatment, did any of the physicians write you a note saying that you couldn't work?
Objection, Your Honor, hearsay.
I can't remember right now.
Hold on. I'm gonna overrule the objection. I'll ask the question a different way, Mr. Hyman. Did you miss work because of this accident?
Yes.
Was it something that the doctors restricted you from working?
Yes. I want to say the chiropractor has said it, but I can't remember off the top exactly what was said.
Okay. Go ahead, Mr. Harmon.
Mr. Ponder, you mentioned copy. Did he reduce that to writing?
I believe it was. I want to say it's in my documents as well. I would just have to go back and look.
And Mr. Spoo, I'll go back to you, and maybe you can pull that up, but I don't see that in the records that we've been provided.
Your Honor, I don't have that. If my client may have it and didn't give it to me, that might be possible.
If I do
have
have
it in our possession.
Okay, go ahead, Mr. Harmon.
Mr. Ponder, there was some reference or about you missing work. Are you seeking any lost wages today?
I did ask about it.
Well, let me ask you this then. How much at the time of this accident were you making?
Anything between 3 on the low end, 5,000 monthly, and that's between doing music and doing event coordination at Rumors.
Was that $3,000 to $5,000 monthly? Was that the answer?
That's correct.
Okay.
You said 3,000 to 5,000?
3 to 5,000.
Okay. And were you paid on a per event basis, or you pay hourly? How were you paid?
The event, I actually had 50% of the night that I ran.
And Mr. Harmon, let me stop you for 1 second, because I think I may need to just educate Mr. Ponder a little bit. I don't know how far this case is going to go, sir, but at some point, if they get into the discovery stage, they're going to be asking for, possibly asking for tax forms. And if your tax forms are not conforming to your sworn testimony today, you may be unknowingly placing yourself in danger. So just please be careful with your responses and be mindful of your responses. Okay, sir?
Yes, sir.
Thank you. Go ahead, Mr. Harmon.
So, Mr. Ponder, what days are you testifying that you missed because of this accident or event?
Tuesdays.
Pardon?
Tuesdays.
How many Tuesdays?
It really went from those 2 months going into COVID. So pretty much, I actually never went back. I actually never ended up going back to Rumors. It went from the time of me being injured to the time right into COVID, and they had stopped doing promoters as a whole.
And let me ask you this, since you mentioned it, this occurred during COVID?
No, this was before.
So the accident was before COVID?
Yes.
Okay. But at some point in time, this accident kind of carried over into the COVID period. Is that correct?
Yeah, of the period of me not working there. Correct.
And so even if you would have been not involved in this accident, was Rumors closed due to the COVID?
Say it again?
For example, say this accident did not happen, but COVID did. Would Rumors have been closed?
I'm not sure if they were open or closed. I just know they didn't do promoters.
But that was because COVID, correct?
Correct.
Okay. Do you have any knowledge of Southern Regional Physicians Management Group? What they may have done for you there?
I can't remember exactly what it was.
Okay. There's been testimony about you having a rod in your right thigh. When did that incident occur?
That was in 2010.
Okay. And for each one of the treatments that you're seeking, in this case, there was a medical person that administered that treatment? Meaning a doctor?
Yeah, from each, I guess each hospital, yes.
Okay. What type of vehicle were you riding in as a passenger back seat?
I don't even remember that part, sir.
Was it a small vehicle, big vehicle?
No, it's small. It was small.
Young, that's all I have at this time.
Any redirect, Mr. Spoo?
I don't think so, Your Honor.
Okay. Do you have any other witnesses that you intend to call?
I do not, Your Honor.
Okay. Do you rest?
We're resting, Your Honor.
Okay. Mr. Hyman.
Your Honor, and I can do this in the form of a bench brief or not, but I would be moving for a motion for directed verdict on causation, medical causation. And because I used to do this quite a bit, with the change in the rules of in 2013 to where we adopted the federal rules of evidence, we're aware that 24-8036 allows you to get documents certified. And so they come to the record as a hearsay exception. However, in Georgia, you still are required, if you need to have causation, to have the medical expert either do a medical narrative or either give you testimony, video, live. That's what we're missing here. And normally, case law stands for the proposition that if it is something of a simple nature, variety, then you wouldn't need expert testimony. However, I'm looking at over $9,000 worth of specials. The gentleman mentioned they're doing x-rays onto his own existing previously injured leg, his head, blurred vision, things of that nature. So to the extent that he's seeking to recover these medical damages, then I move that he's failed to prove on causation. Also, we've never waived from the standpoint of proper party and interest. And that's what I'd like to also put that in a brief that, but there's no indication from the original complaint that they properly gave analytic notice to the city or that Officer Pierre is the real party in interest.
That is, those issues are issues that I really want to take under advisement and to have an opportunity to actually do some research on this.
And
yes, go ahead, sir.
And that was just on my DV, but as it relates to just my case in point, and then I'll, if the court allows us to brief it, as it relates to medicals as well, and this is, I guess I've been in my case in chief. While we know under the statute in Georgia that a person can give testimony about their treatment, it is a rebuttable presumption. And that's why I went into asking Mr. Ponder about what type of treatment was entailed for that particular reason, because it is a rebuttable presumption. And so to the extent that he can offer more than I was just there type of testimony, then I believe that he had met the burden in terms of proving his medical expenses specials. Also, at this time, just for the limited issue as it relates to real party, I'd like to call Sergeant Pierre just asking one question, whether or not he's on duty on the day of the accident.
So I'm going to accept he was in a city issued police car and that he was wearing his uniform. That's certainly enough to get you arrested for running from the police, whether the police officer was on duty or not. So I think it should work in the opposite direction. There's Mr. So I'm going to bring something to your attention.
Yes, Your Honor.
That I don't try to hide the ball with people. I want to be as prepared as possible and to give people as much notice as possible. And I can't find it now. But it's from there's something I observed that was a Southern Regional record, and it talked about your client's damages. And unless I can find it right now, I'm going to have to just paraphrase it. But it said that there was discomfort in the leg, and it said a mild headache, and it said something else. And right now, when you know it, when I want to bring it, it's in the 92 pages that were filed as part of the complaint. But so let's assume that Mr. Hyman loses. When we're talking about damages, I'm looking at the treatment that was given as it relates to what is appropriate amount of damages. But it was, and I believe it was from Southern Regional, and it was just sort of a discharge summary explaining what happened.
Yes.
So that'll be something that I would love to hear about, as to whether, assuming Mr. Hyman is wrong and damages are to be ordered in this case, the amount of damages, of course, is something that the court has to look into.
Yes.
And so it didn't appear from how I read that Southern Regional discharge summary that there was like damages. And with the right leg, and the fact that the right leg was injured before, those are things that I will be taking into account if I rule against Mr. Hyman and I rule in your favor. So I would like to hear from you as it relates to those issues.
Well, Your Honor, I mean, we presented numerous pages of medical records. There's diagnoses, not only in his leg, but in his cervical spine and lumbar spine. And again, we're standing on there. They were certified records. And that's our position, that he was injured from this accident. Again, I don't have the case law off the top of my head. Counsel's making, bench arguments verbally and not via, motion, and allowing time to respond for multiple things. And again, as much as I like to think I'm versed, I'm not going to be, I'm not going to be proud and say that I would like to look up what he's discussing and make my own arguments against the same.
And I have not made a decision. And that's the purpose of this, is because I believe that these are novel issues. Not novel, but these are issues that I'm not well versed in. And so I want to give both parties my best effort so that I can then, learn, read the case law, learn what I need to know. I used to be a personal injury lawyer at one point in my life, and I understand what it entails in going through certain things. So I'm not going to give anybody short shrift. Everybody's going to get their fair day. And if I knew the answer, I'd tell you, or believed I knew the answer right now, I'd tell you what I believe I know. I don't know the answer right now. But I'm going to educate myself. And Mr. Hyman, you're going to, of course, have to share your arguments with opposing counsel, and opposing counsel share your arguments with Mr. Hyman. And then I want everybody's best foot to come forward so that I can make sure that Mr. Pierre and Mr. Ponder are treated fairly.
Thank you, Your Honor. We appreciate you.
Okay. All right. So do I get to end this marathon day and now got to spend a couple hours signing orders? So is there anything else, Mr. Ponder?
No, sir.
Is there anything else, Mr. Pierre?
No, Your Honor.
Okay. Is there anything else, Mr. Spoo?
Not at this moment, Your Honor.
Is there anything else, Mr. Hyman?
Your Honor, if the court desires and we want to make just kind of written submissions on the points of law that we raised, what would be the best way to get that to Your Honor?
I'm gonna put it in the chat.